I'd like to call to order the February 5th, 2024 meeting of the Charleston County Board of Zoning and Appeals, also known as the BZA. The board members that will hear your case tonight are as follows. My name is William Ray. I'm the chairperson. To my right, we have Mr. Truslow, Mr. Martin, and Mr. Siddell. To my left, we have Mr. Nelson, Mr. Jordan. Mr. Williams. Ms. Switzer Smalls, I think, will not be here today, so we will have some people coming in. Staff members present tonight, Mr. Anderson, Ms. Brooks, Ms. Clark, Mr. Downey, and Ms. Working. The attorney for the BZA is Mr. Kevin D'Antonio. Because the hearing tonight is a public fact-finding meeting, we are in compliance of the Freedom of Information Act and South Carolina Code 6-29-70. 15 days prior to the announcement was printed in the Post and Courier. A sign was posted on or near the designated property, and a notice was mailed to the applicant or the applicant's representatives, to the property owners within 300 feet of the property, and to parties within of interest. Persons, organizations, and news media have also required or requested declaration of our meeting, and they have also been notified. Board members, the meeting notes for January the 8th, 2024, public hearing, were emailed to you. Are there any changes? If not, can I get a motion to approve and a second?
Motion.
Okay, approved and a second down there from Mr. Williams. All those in favor, please indicate by saying aye.
Aye.
Aye. Any opposed? Abstain. It carries. Thank you so very much. Our case ruling from this and any BZA meeting are available to the public, review and inspection during normal business hours at the Charleston County and Planning Department. The Board of Zoning Appeals is a quasi-judicial body that has final decision-making authority on the following: appeals of a zoning-related administrative decision. The BZA is authorized to hear and decide appeals only on zoning-related matters where it is alleged that there is an error in the order, requirement, decision, or determination made by the administrative official in the administration or enforcement of any zoning-related regulations. A 2/3 vote of this quorum present is required to overturn the decision of the planning director in an appeal. We also have a special exception. A special exception is issued by the BZA authorizing a particular use in a specified location within the zoning district upon demonstrating that such use complies with all the conditions and standards specified in the Zoning, Land, and Development Regulation Ordinance, also known as ZELDAR. The BZA must find that the special exception meets all 6 of the approval criteria in the ordinance in order to grant a special exception. A simple majority is required to grant a special exception. And then finally, we have a variance. A variance is a relaxation of the BZA regulations of the ordinance, where such an action will not be contrary to the public interest and where, owing to the conditions particular to that property, or is not in results of the actions or situations of the applicant, a literal enforcement of the code will result in the unnecessary and undue hardship, and such a variance is consistent with Section 6-29-800 of the Code of Law of South Carolina, Title 6, Chapter 29. The BZA must find the variance meets all 7 of the approval criteria in the ordinance in order to grant a variance. A simple majority is required. Our purpose tonight is for interested parties to be heard in order to assist this board into gathering evidence pertinent to each case. If a member of the BZA feels need for further information to clarify a case, the board has the authority to subpoena witnesses. It must be understood that your neighborhood, that the rules in your neighborhood or the subdivisions are binding, and we can take no actions to negate their jurisdiction over your property. In addition to your testimony, the board has been presented written information submitted by staff, by the applicant or the applicant's agent for each case. This information is now considered evidence and is entered into the permanent record of this body. It is assumed to be true, complete, and accurate. In addition, we have been presented data assembled by staff for the purpose of clarifying the location and the applicant's effect on surrounding properties. The board is empowered to approve with conditions, or deny a special exception or variance request. We are also authorized to defer a case should there be a need to obtain additional information. The BZA's final decision will be mailed within 10 working days of this public hearing. It will be mailed certified mail to the applicants and regular mail to the neighbors and the communities of interest. If an applicant's request is approved, the applicant should contact the Charleston County Zoning and Planning Department staff to discuss the next steps in the process. Variances and special exceptions granted this evening are valid for 12 months after this meeting, and a 1-year extension may be granted if only construction or development has been commenced or is being diligently pursued. However, if an applicant's request is disapproved and if the applicant wishes to appeal the decision of this board concerning the case, an appeal must be addressed to the circuit court. South Carolina Code 6-29-820 states that an appeal must be filed by the applicant within 30 days after the decision of this board. Failure to file the appeal in a timely manner deprives this court of its jurisdiction to hear this matter. Because this is a quasi-judicial body, everything said in this meeting must be true, complete, and accurate. All the information provided to the BZA in concern or is considered evidence, and this board may certify contempt of circuit court if false testimony is either made orally or in writing. Therefore, each person who wishes to address the board will be sworn in by the BZA secretary before they provide testimony or evidence. In order to expedite this process, please stand as a group, and our secretary will administer the oath.
Please stand and raise your right hand. I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do. Thank you.
That looked like everybody tonight. Okay. Everybody wants to talk. Okay. I will now call each case by case number. Staff will present facts pertinent to the case, limited to 5 minutes. I will then call the applicant. The applicant will stand and state his or her name and current address for the record before presenting testimony that is pertinent to the case, limited to 5 minutes. I will then ask those speaking either in support or in opposition of the case. They will follow the same procedure for identifying themselves and are limited to 2 minutes each. The applicant will then have a chance to reply to any opposition. We want to limit that to 2 minutes. And the BZA will make a motion to close the case to the public. Finally, the BZA will make a motion concerning the application stating findings of facts and conclusion of law. Tonight we'll hear 9 new cases, and the first case we'll ask Mr. Dowie, if you would please introduce case BZA 12-23-00735.
All right, BZA case 1223-00735. The applicant, Larry Zinger, Ajar Construction, Inc., and the property owner. $735.
Oh, okay. That's Tracy. It's Tracy.
Oh, that's right. They changed that.
Sorry.
Sorry, that was a
There was a change in applicant.
change in applicant. So Tracy Helms of Velma Instant Oil Change On behalf of the property owner, Mike C. Harper of GH Latson LLC, are requesting a variance for the loading area of the dumpster to face the right-of-way for a proposed vehicle surface use at 3746 Latson Road, TMS number 389-0000125 in the north area of Charleston County. The subject property is located in the Community Commercial CC zoning district. The adjacent properties to the south and east southeast and west are located within the city of North Charleston's jurisdiction, and the properties to the north are located within Dorchester County's jurisdiction. The property is currently going through the site plan review process. Case number ZSPR 0823000927, and the applicant's letter of intent explains the instant oil change proposed building is 3-bay quick oil change. The building is a drive-through, whereas there are overhead garage bay doors and entrances and exit buildings. The subject property is a corner lot with frontages on Latson, Miles Jamison, and Old Miles Jamison Road. We are seeking relief from the Zoning and Land Development Ordinance, Section 9.5.2, Architectural Design Guidelines, Paragraph E, Building Orientation. Letter 4, building shall be oriented so that the loading area shall not face residential districts or use existing right-of-ways or from plain future right-of-ways. So that is section 9.5.2. The subject property. An aerial view of the subject property. And a zoomed out aerial view of the subject property. So staff did conduct its site visit on January 17th. And these are some pictures of what is currently there on the subject property. So that is Elias Court, Jamison Road, Latson Road. Here are some of the pictures from the development drawings. So that is the survey and the site plan. This is the landscape plan. Along with the elevations. More of the elevation. And here is the trash enclosed plans. The plat of the property. So staff believes that it meets criteria 1, it meets criteria 2, it meets criteria 3, it may meet criteria 4, it meets criteria 5, and it may meet criteria 6 and 7. So the Board of Zoning Appeals may approve with conditions, or deny BZA case 1223-00735, a variance request for the loading area and dumpsters to face the right-of-way buffer, vehicle surface use at 3746 Latson Road, TMS number 389-0000125, in the north area of Charleston County, based on the BZA's finding of fact, unless additional information is deemed necessary to make an informed decision. The board may modify any of staff's recommendations below and should consider the following recommendation by staff. Prior to the zoning permit approval, the applicant shall complete the site plan review process. Any questions?
Does the board have any question? Yes, sir, Mr. Marchant.
Thank you, Mr. Chairman. Mr. Downey, under the, let me pull this up, the building orientation section in Zeldar, section E, it talks about they shall not face, loading areas shall not face residential districts or uses, existing right-of-way or planned future right-of-ways. Are there any residential areas around this? I mean, it looks like it's all commercial based on the
So
vicinity map.
if you go on, and I have these are all residential houses, and that's the ones that are in Dorchester County's jurisdiction.
Right.
All of that is single-family residences.
Okay.
This is another commercial lot. That used to be a gas station. Used to be a gas station as well. This is currently a gas station. This is a shopping center, but all of this back here are residential, single-family residential homes.
Okay, so the road that it's facing, is it Jameson Road? Where
So
the
actually, this
majority-
property has a triple frontage.
Right. This is part of
So-
the problem.
Yeah,
But-
old Jameson Road this is old Jameson Road. This is Jameson Road, and then this is Latson Road.
Right.
So the houses are along Old Jameson.
Right. And the bays kind of face Jameson and Old Jameson, I guess.
Correct.
So the other part of my question, and my computer's messing up here, but if you have a screen wall, that's okay, but it doesn't look like there's a screen wall. So part of Section 5 talks about a screen wall, if I recall. And
I will yield that question to Ms. Brooks. She
Okay.
would have the answer for that.
Some projects, they have incorporated as part of their architecture of their building, a wall that sort of wraps around in front of where the roll-up doors are, and that has met the ordinance.
So is it fair to say if we had a screen wall, then we would be sitting here tonight?
So it needs to be like attached to the building,
Okay.
an integral part of the architecture of the building, not just a screen wall.
Okay, thank you.
Any other questions? You have a question? Thank you, sir. Is the applicant present? Very good. Please come to the podium. You have 5 minutes, sir. Please state your name and address. But before you do, ladies and gentlemen, we do have monitors down here before us, and that's why you may not always catch us looking back behind us. You'll also notice that we'll post the time that you have left up there, right? So please govern yourselves accordingly. Thank you so very much for your patience, and please state your name and address for the record, sir.
My name is Tracy Helms. My address is 1019 Troy Medlin Road, Monroe, North Carolina. Staff did a great job.
Just a little louder, please, sir. We can barely hear you.
Certainly.
Uh-oh.
I don't have much to add to what staff said. We're trying to develop a quick auto service station. Our business model depends on cars driving through our building. That dictates doors on one side and doors on the other side. So we tried to orient the building to face the least traveled road. Of course, it faces the rear lot as well. But are there any questions for us?
Board, do you have any questions? Then on that side? I guess not.
Okay, thank you very much.
Do we have anyone else to speak in favor of this application? Do we have anyone else to speak in favor of this application? Do we have anyone to speak in opposition to this application? Anyone to speak in opposition? Very good then. This case is closed to the public. And at this time, board members, do we have any questions of staff? Any general questions? No discussion. Therefore, gentlemen, I need a motion to either approve or deny this first case. Yes, sir.
I'll make a motion.
Very good.
I would make a motion to approve the request for a variance. On behalf of the property owner, the applicant is seeking a variance for the placement of a loading area and dumpster to face the right-of-way so as to facilitate vehicular traffic. It appears that this is the most reasonable, safe method to do this. The zoning is community commercial, and the legal authority is set forth in Charleston County Zoning and Land Development Regulation Ordinance 9, in particular 9.5. And I'm sure most people know this, but we want to make sure if anybody ever had any questions for an appeal, there'd be a record that we would state the reasons why we've done things. This matter has been thoroughly investigated by staff, as they always do. The presentation was cogent. It was well documented. There was proper notice. The property in this case is triangular in shape, which makes it somewhat difficult to build on if there weren't to be a variance, and it's been that way for a long time. You've got Ladson Road, you've got Miles Jamison Road, and then the old road. This makes it appears to me to be the most appropriate, reasonable way to serve the public, and there's a need. The aerial views demonstrate the layout and the nearby properties as well. I noticed that they were in Dorchester County, the residences, but they were some distance away. Again, this is a commercial community zoning in nature. The request is properly noticed, thoroughly documented. It's undergoing site review. There's a letter of intent reflecting they wish to install 3 quick bay oil change bays or a facility. I've relied on ordinance chapter 9. The relief is to be reviewed on a case-by-case method pursuant to section 3-10-6. I would move to grant the variance on the basis that it meets all the criteria. There are extraordinary and exceptional conditions. I've stated the reasons, including the layout of the property. The intent of the zoning ordinance cannot be met if there was going to be a strict compliance with the law that would be unreasonable and impose an unreasonable burden on the applicant. The conditions don't generally apply to other properties. This is an abandoned gas station, and the project is designed to promote the public good. Development will enhance the public good and provide a valuable public service. The variance will not allow a use that would be otherwise prohibited by law. This situation is not a result of the applicant's own action. It's just the nature of the property that exists. They wish to use the existing property in a productive manner, and this does not substantially conflict with the comprehensive county plan nor its purposes. In fact, it would meet those. I would conclude that this is well considered. It provides a beneficial use to the community. There's no evidence of harm that's been presented, and it will not harm established property values in the area. So I would make this motion provided that the site plan review progress is completed prior to zoning permit approval. And that would be my motion.
All right, we got a motion on the floor. Do I have a second? Second. All right. Any discussion? I'll call for the question. All those in favor, please indicate by saying aye and raising your right hand. Aye. It is unanimous. Thank you so very much. Sir, your application has been approved. Within 10 business days, you'll be getting information from our staff, letting you know the next steps in the process. Very good. Our next case is case BZA 12-23-00736. And Mr. Downey will be doing that one as well. Good job.
All right. So BZA case 1223-00736. The applicant and property owner, Arcia Harville, is requesting a variance to reduce the required 3-foot interior side setback by 2 feet to 1 feet for an existing detached accessory structure, a carport, at 1641 Oak Island Drive, TMS number 32803000069 on James Island in Charleston County. The subject property and all surrounding properties are located within the low-density R4 zoning district. The .3 acre subject property contains a single-family residence that was constructed in 2001 per Charleston County records. The accessory structure in question was placed on the property in 2020 per Charleston County records, but no permits were obtained before the structure was erected. The applicant purchased the property in 2022 with its current conditions. The applicant's letter of intent explains, "We purchased this home last October where we are planning to renovate the home and had the property surveyed. Once we started the zoning permit process, we were informed that the carport was not permitted and encroaching in the side setback of the property. We would like to get a variance and approval of the carport before we can start the proposed renovation project." So that is section 6.5.8 that deals with accessory structures, detached accessory structures. And section 3 states that detached accessory structures in R4 can be located 3 feet from the property line. So that is the subject property. And that is a 300-foot radius map. That is an aerial view of the subject property. And a zoomed out aerial view of the subject property. So staff conducted its site visit on January the 17th. Here are pictures of the carport. More pictures of the subject property. Oak Island Drive. Spearfish Circle. This property has a double frontage. That is the site plan. And the plat. So staff believes that criteria 1 may have been met. It meets criteria 2, 3, 4, 5, and 5, and it may meet criteria 6 and 7. So the Board of Zoning Appeals may approve with conditions, or deny BZA case 1223-00736, a variance request to reduce the required 3-foot interior side setback by 2 feet to 1 feet for an existing detached accessory structure or carport at 1641 Oak Island Drive, TMS number 328-03-00069 on James Island in Charleston County, based on the BZA's finding of fact, unless additional information is deemed necessary to make an informed decision. Staff does not have any recommendations for this case. Any questions?
Any questions?
I have a question.
Yes, sir, Mr. Truesdale.
And I guess I'm one of the newest members on this board, so forgive me if I don't know the answer to this directly, but there should have been, is it correct, there should have been a permit that was obtained by the prior owner or the builder. Is that correct?
That is correct.
They didn't comply with the law.
Did not.
And all that's been within the last 3 years.
Correct. So
So
this was
if
placed on the property per Charleston County records in 2020.
So if somebody wanted to, there would be recourse given that it's less than 3 years for statute of limitations purposes.
No, we don't necessarily
not
do
you.
statute of limitations purposes.
Not
if
you.
if there's a violation on the property, the violation follows the property in perpetuity until a permit is brought.
All right.
So if this was placed on the property in 2005 and never got a permit, we would still require a permit now.
I didn't state that very well, not you, and it follows the property, but the current owner would have recourse if this were denied. They would be able to go back and complain to the prior owner.
That is outside of
builder.
our,
Not sure within your.
yeah,
bailiwick.
that's not our playground to play in, but yeah.
What is the cost of a permit? What would it cost somebody to?
For a zoning permit for a detached accessory structure is $25.
20, that's all it would have taken?
That's all it would have taken. Building services has their own fees, but for us, it would have been $25.
Okay.
And a variance request to do what they did.
And they would have to file a variance request and pay $25.
A variance request in this case, if they would have come in, we would have told them if the previous property owner would have come in, we would have told them to make it 3 feet from the property line and not 1 foot from the property line, so they wouldn't have come to this board. But since that is not the case, that's why they are before you tonight.
That's why we're here. And does anybody have any authority to do anything when somebody violates the law? What are the recourses?
I do not have that answer. Zoning is a little more forgiving than some of the other departments. Building services may do something like put a double fee on the property, but I don't really have that much data. I just know that that is something that has happened in the past. But zoning is a lot more forgiving than the other departments are, as far as recourse is concerned.
Thank you.
Good questions.
Well, didn't know.
Hey, when you know better, you do better.
All right.
Thanks, Mr. Chairman. I mean, maybe just a comment, Mr. Downey, because I really appreciate the question. We've had a few forgiveness cases up here since I've been on the board, and we are in a tough situation because the current owner hasn't done anything wrong, per se. The previous owner did. Whether they knew it or not, hard to say. But I know from previous personal experience, when you purchase real estate, if there's a problem, you can go back to the seller and duke it out, right? And see where, I mean, we have a professional here that might be able to comment on that a little better. But it does beg the question, could county council create situations where forgiveness cases like this do have recourse? Because it gives us a little more meat to put on the bone if we had to. Otherwise, we're just sort of stamping the wrong, right? So just a comment.
That is something that we would take up the ladder and see where it goes.
I would encourage it.
Any more questions? Thank you, sir. Is the applicant present? Please come forward to the podium. Please state your name and address for the record, and please tell us why we should approve your application.
Good evening. My name is Erica Harville Hawkins, and I live at 1641 Oak Island Drive in Charleston, South Carolina. So this basically started back when my husband fell in love with this house, and he promised me we would get it remodeled if I agreed to it, so I did. And we started that process in October of 2022. We got our architect, our structural engineers, and we had everything we thought we needed to begin that renovation of the inside of the home. But we quickly found out that that was not the case when we went for our zoning permits. We had no idea that there was an issue with the carport. When we bought the house, they didn't catch that. There was no issue with any encroachments. When they did the survey, it says in the survey, I see no issues with encroachments or easement with this property. So we were under the impression that the home was, good to go and there were no issues. We've met with all of our neighbors. We know them all pretty well, and they have all signed. I think you should have received statements stating that they have no issue with us keeping it, even the neighbor that lives directly behind us. We want to redo this home to raise our family in, and we would really like to keep the carport if this board would approve that. So that's all I have. I don't know if you have any questions for myself.
I most certainly think they have a few questions. Mr. Truslow, you have a question? No, I want to start with you because you started it.
Oh, I started it. I'm sorry. Well, I'm start off with a compliment. It's laudable that you've come here and not done what was done before. We wouldn't be here but for what somebody else did. My first question is, when you find out you buy the house, you realize and you're shocked to find out that you got a problem.
Yep.
I would think the first thing you did was you went to the former owner and said, "Why didn't you tell us about this?" Have you talked to them?
No, I mean, I have the former owner's name. I could contact, I guess, the real estate agent. We are under the impression that the carport was actually built by the original owner back in the early 2000s. All of our neighbors says it's been there for decades. Lance, who, I don't know his last name, but he built the home. He actually built the carport as well. So it's been there for well over 20 years. I'm not sure what happened in 2020 for the county to have thought that that was built then, but all of our neighbors have told us that it was built early on with the house. in the early 2000s. So we would have to go pretty far back to,
Well, yes, ma'am. That was part of my confusion. It looked,
Yeah.
from what I read, unless I misunderstood, I thought that it was done in about 2020. Is that incorrect? Or is there dispute?
It says 2020 on here.
2020?
yeah, all of our neighbors have stated that it's been there for, I mean, they've been there since the 80s, and they said that that was built with that. And if you looked at it, there's no way they could have matched the driveway, and the wood that was used on the house was used on the carport. So it's likely that it was built long before 2020.
So you don't, and I don't know, but I'm not a real estate lawyer, but did you have a survey, or did it not show up on the survey?
No,
Do you
the
have
title
survey?
company didn't catch it. The appraisal, it wasn't caught in anything when we purchased the home. No one told us that there was an issue with the carport, and everything went through as if there were no problems.
And I guess the name of the builder is lost in the fog of time.
I think the original builder was, his name is Lance. So our neighbors know who built it, but I mean, it was back in the early 2000s. So where he is, I don't know.
All right, thank you.
So the 2020 date comes from the assessor's office. That's when they say it was built, but probably when they discovered it, is what my guess is.
Mr. Williams, you had a question, sir?
Well, just for how you doing? Just for clarification, you said that you all are renovating it to live there yourselves?
Yeah, we hope to renovate it. We are living there, and we plan on living there after we renovate. We're just basically, adding a bedroom, a bathroom, and new floors, new bathrooms, stuff like that.
So when exactly did you all find out that you were out of compliance with that garage? What part of the process
So
of
we
buying the house?
were in the process of, I had just gone on the website and put in for a construction permit. And I guess there was some portion of that requires a zoning permit. And that's when someone said, wait, this carport is encroaching on an easement. You have to get a variance before we can move forward with a zoning permit. So we pretty much stopped in that process in October.
and
So we haven't done anything.
How far after buying the house did that happen?
A year. Yeah, it was over a year. Because we met with architects, structural engineers to have the plan ready for our renovation. So we were doing that the past year. So we had no idea that we would be here today.
Mr. Jordan, did you have a question, sir? No, sir. Welcome aboard, Mr. Jordan. Any other questions? Thank you so very much for your testimony today.
Thank you.
All righty. Do we have anyone else to speak in favor of this application? Do we have anyone else? Yes, that's the husband, right?
Yeah. My name's Joe Hawkins. I'm the husband who begged and pleaded to get this house near the beach. We have 2 small kids. I just promised my wife that we could renovate this house. I'm not a developer. I'm just a simple accountant, and this just seems to be an arduous process. Had we known previously when we bought the house, we would have certainly gone through the steps or tried to mitigate any issues that we have before you tonight. And I just ask that you give us a little leniency on this, just so I can get some walls and get my kids to sleep and some bedrooms in, and that's it, man. We want to live there. We love Charleston, and we appreciate your help in this matter. Thank you.
Hold on. Let me see if anyone has a question for you. Does anyone over my right have a question? Yes, sir.
Just one question. You had a list of neighbors who supported your application for a
Yes, sir.
variance. Is that, and I was trying to find their letter, but does that include the neighbor that's in lot 40? The Johnsons, William and Shanna Johnson, are they one of the people who signed?
Yes.
They did? Okay, thank you. Sure.
Let's see. Hold on. Anyone else on my right? On my left? Thank you, sir.
Thank you.
Do we have anyone else to speak in favor of this application? Do we have anyone to speak in opposition? Do we have anyone to speak in opposition? Very good. This case is closed to the public. Board members, do we have any questions of staff? Any general discussion? All right, then
I have a couple of comments that worry me, and this isn't going to be necessarily determinative, but hope this comes out right. We shouldn't be condoning misconduct and the breaking of law. That's on one hand. On the other hand, this certainly was not I'm convinced that this was not the fault of the current owner, and that this was done, that this addition was done long ago, and it just was caught by the appraiser's office in 2020. It appears that it's been there for a long time. It's frustrating that we don't want to encourage people to break the law in the future by just not getting a permit, not complying with the law, and then selling the property, and then everything's okay. So I hope somebody can address that for me. It bothers me about condoning misconduct, and we shouldn't be in that business. On the other hand, again, this is not the fault of the current owner.
Well, truly stated, that's why they're coming here for relief, but that has to be dealt with county council first, and then our other representations that govern this beautiful state of South Carolina. It's we have to deal with it the way we get it. So unless you feel really strongly about it, you can make a motion to grant them some relief tonight.
If I can make a comment to that.
Yes, sir.
There's a lot of cases that comes in front of the board here that where there is an applicant who's directly asking for an ordinance for a plan that he has at that point in time. So, I could see not allowing them to break, as you said, the law, but this being a previous construction and stuff like that, I feel like it's, we could allow them to move forward. But to your point, a lot of people will come with plans and want you to approve something, or the board to approve something that's a current plan. So to your point.
Mr. Williams, that's why we have this august body,
Right.
to make those decisions and determinations.
So when we have a plan directly in front of us that's residential, and they're just asking this board to approve a plan they have now that they want to move forward on, then that's something that's more immediate. That we're like, well, we can't allow that. That's kind of my point of view.
All right.
I have one more.
Let me go down to the end.
No, I was just going to say, the reason I asked if the neighbor whose property adjoins the carport had a problem and had signed in support, they're the ones that would be most adversely affected. If they want to sell their property, somebody may object to the fact that this carport is almost on the property line. But they're not concerned, and they're realizing that if they ever sell their property, they've agreed to this. So in my mind, that negates a little bit of the impact of approving the variance.
Mr. Truesdale?
I agree with that reasoning, and it's the other side isn't going to be persuasive to me. But the fact that the current neighbors don't necessarily care isn't completely persuasive, because at some point in time, properties are going to be sold, and you're going to have new neighbors, both that haven't been a party, and say this applicant's neighbor wants to build right up to the property line, and the subsequent purchaser from this applicant doesn't want to let them do it. We're creating the potential for more problems. That isn't going to be dispositive, but that's something that.
So this is why it's being put on record and being stamped and sealed, however we rule, and it'll be public knowledge for anyone to see as anyone comes and goes, as property is sold and purchased. So it'll be a matter of record. So whatever determination is made tonight, it will be out there. All right, gentlemen, I'm going to call for the question. I need a motion, excuse me.
I'll go ahead and make a motion to approve, and I was going to add to it, but I'm good. So in the matter of BZA 12-23-00736, I make a motion that we approve this request for a variance. In so doing, I find that it meets all 7 of the necessary criteria, that there are extraordinary and exceptional conditions pertaining to the piece of property, to this particular piece of property. Yeah, I'm compelled by the applicant's argument that they bought the property with no knowledge of the violation that had occurred, and I think they're taking the right steps to rectify the situation by obtaining the variance so they can move forward with their project. So we meet that criterion. For criterion 2, the conditions do not generally apply to other property in the vicinity. We really don't know whether or not there are other structures in the vicinity that may or may not meet this, have the same setback issue, but I do feel that we are in compliance with that criterion. For criterion 3, that because of these conditions, the application of the ordinance to the particular piece of property would effectively prohibit or unreasonably restrict utilization of the property. For this criterion, I actually think that requiring the homeowners to move the structure 2 feet to be in compliance with the ordinance in a situation where all of the neighbors are on board and it was not by the applicant's doing, we would be placing an unnecessary hardship on the owner by requiring them to move the structure. So I believe we meet that criterion. For criterion 4, the authorization of the variance will not be of substantial detriment to the adjacent property or to the public good, and the character of the zoning district will not be harmed by granting of the variance. And clearly, this structure does not have a detriment on the neighboring properties or neighborhoods, so we meet that criterion. Criterion 5, the BZA shall not grant a variance, the effect of which would be to allow the establishment of a use not otherwise permitted in the zoning district, or to extend physically a nonconforming use of the land. We meet that criterion. There are no we're not trying to change the use of the property. Criterion 6, the need for the variance is not the result of the applicant's own actions. It's clearly not something that they did but was done by a prior owner, so we meet that criterion. And criterion 7, granting of the variance does not substantially conflict with the comprehensive plan or the purposes of the ordinance. The same use will carry, so we meet that criterion as well. There are no special conditions, so Mr. Chair, that is my motion.
All right, do we have a second? Second. Okay. We have several seconds. That's good. We'll go with yours, Mr. Truesdale, since you're closest to me. How about that? Any discussion? Questions? All right, all those in favor, please indicate by saying aye and raise your right hand. Aye. It is unanimous. We had a struggle here tonight trying to get you this thing approved. So within 10 days, you'll be getting information from our staff, letting you know the next steps in the process. Your application has been approved, so congratulations and good night.
Mr. Chair, it was only a 5-month delay in their permitting process, so what's another couple of minutes of discussion?
Yeah.
Another 20 minutes?
They'll probably go out and have a good meal tonight, have a glass of wine and celebrate. There you go. Or have one on us.
Be safe out there.
Okay, ladies and gentlemen, we will combine 3 cases tonight. Our next case is case BZA 12-23-00737, 738, and 739. And Ms. Working will take care of that one for us.
All right. Yep.
Thank you, Ms. Working.
The applicant, Travis Bedingfield of Kia Country of Charleston, and the property owner, John Lee of Harbor City Investments LLC, represented by Kelsey Santiago of Hussey Gay Bell, are requesting 3 variances for proposed renovations, additions to the existing vehicle sales and service use at 2355 and 2361 Savannah Highway. And that's TMS number 310-06-00108 in the St. Andrews area of Charleston County. The 2.86 acre property is located in the Community Commercial CC zoning district. Surrounding properties to the north, east, and west are located in the CC zoning district. The properties to the north, east, and south are located in the City of Charleston's jurisdiction. And there is 1 property west of the subject property that is located in the low-density residential R4 zoning district. This project is currently in the site plan review process. The applicant is proposing to renovate the existing 3,900 square foot building and to renovate and construct a 3,200 square foot addition to the existing 6,042 square foot building that will include 8 vehicle service bays for the Kia Country of Charleston car dealership. So the first variance request is a request to encroach more than 25% of the protected area of a grand tree More specifically, the applicant is requesting to encroach a 30-inch DBH grand live oak tree, and the encroachment is 56.9%. The second variance is a request to reduce the required 8-foot perimeter landscape area. And the third request is a request for the loading area to face residential districts or uses. These are all the ordinance requirements for each case, the radius map, and this is a aerial photograph and a zoomed out aerial. This is the posting for the first case. We conducted a site visit on January 17th, 2024. We did get a call, I believe earlier last week, that there were some signs missing, so we went back out on the 30th of January and reposted 3 signs. This is the 30-inch live oak that they're proposing the 56.9% encroachment. Another photo of that. And I have photos of the subject property. Mutual Drive and Savannah Highway. This is the posting for the second variance and the third variance. This is a survey of the property and the demolition plan, the tree protection plan, and this is the proposed site plan. They've also included the landscape plan and plat. We received 12 letters of opposition, and that's in your supplemental packet. For variance number 1, we stated that it may meet 1, 2, 3, 4, 6, and 7, and that it meets 5. For variance 2, which is the landscape buffer variance, we stated that it may meet 1, 2, 3, 4, and 7, that it meets 5, but it may not meet 6. And we stated that's due to the redevelopment of the site. The buffer could be created along with the other plan improvements. Therefore, the request may not meet this criterion. For case 3, we stated that it may meet 1, 2, 3, 4, 6, and 7, and it meets 5. The board may approve of conditions or deny the cases based on the BZA's finding of fact unless additional information is deemed necessary to make an informed decision. In the event the BZA decides to approve the application, staff recommends the following conditions, and this is for case 1 or 00737. Prior to zoning permit approval, the applicant shall complete the site plan review process. 2, if the grand tree requested for encroachment, the 30-inch DBH live oak, dies within 3 years of installation of completion of the project, the applicant shall mitigate the tree by either A, submitting a mitigation plan for review and approval indicating the installation of canopy trees no smaller than 2 1/2 inches in caliper, equaling inch per inch replacement. B, by depositing funds into the Charleston County Tree Fund as described in section 962 of ZELDAR, or C, a combination of both A and B. The allotted mitigation shall be in place prior to its removal. 3, tree barricades constructed of chain link fencing shall be installed around all protected trees within 40 feet of disturbance prior to any construction pursuant to section 924 of the Charleston County Zoning and Land Development Regulations Ordinance. And 4, the applicant shall retain a certified arborist to monitor and treat all grand trees on site through the duration of construction. The applicant shall provide a copy of the treatment plan to zoning staff for review and approval prior to site plan review. For case ending in 00738, we had prior to zoning permit approval, the applicant shall install a 6-foot high opaque fence along the eastern property boundary, and the applicant shall complete the site plan review process. For case ending in 00739, prior to zoning permit approval, the applicant shall install a 6-foot high, prior to zoning permit approval, the applicant shall complete the site plan review process. The fence was for the second case. Any questions?
Yes, sir, Mr. Marchant.
Thank you, Mr. Chairman. Ms. Working, do we have any other exhibits from the applicant? I mean, we have site plans, but it's hard to ascertain the bays how they might affect the residential area. So I guess one question is, do we have any other exhibits? And the second question is, can you walk us through the area that it's difficult? I don't know if it's because my iPad's acting up or it's because it's me. I'd like to think it's the iPad, but it's difficult to understand exactly where the relief is being asked for each. The tree's easy to find. That's easy. The buffer and I'm not very clear on because I'm just having a hard time without a lot of information submitted by the applicant.
And they did not submit elevations for BZA. I believe they did for site plan review, but that would have been.
Okay.
Sally's gonna.
Okay, yeah. So looking at the site plan, you'll see on the right, the eastern property boundary.
Thank you.
That's the relief from the vehicular use buffer.
Can you hit that with a laser, Ms. Working, please?
This side?
Thank you. Yeah. Okay.
Okay. So you have the tree. So the bays for the building is the building at the most rear building furthest away from Savannah Highway. So there were two properties that were combined. The Kia property that was existing and then an adjacent property that I believe used to be like maybe a car wash or something. So there's an existing building along the back there, and there's some existing bays that they use to service. They're actually extending that building out into where the old property or the other property was. Hope I'm explaining that good. It is that if you zoom in on, I lost my plan.
That sheet's
If you zoom in on that
yeah.
sheet, you can
Yep.
see a little detail on that where the existing building wall is, and then the proposed extension of that. You can see that if you zoom in. Yeah.
Correct? Mm-hmm. Okay.
Right.
Yeah, that makes sense. Thank you. Back bays face the residential area to plan bottom.
Yeah.
Yeah.
The intent is to be able to pull a vehicle all the way
Yep.
through. Yeah. Or they're double loaded. Right.
Mr. Nelson?
Are there already bays on that building?
There are.
Okay.
Yes.
And just
I
because
believe
they're
they're
additional,
four. Yeah,
they're
they're-
renovating the building, and that's what's causing the need for a variance now.
Yeah, so they're basically extending it to add more bays. There are some existing there, so they're just going to make a continuation of that to create more.
Vegetated buffer. What's next door to the property on that side? Is that a storage facility, storage sheds? Is that correct?
Let's look at the aerial. Yes.
Okay. All right. And then on the south side, where D buffer?
So that's the width, and there's a certain amount of vegetation that's required based on that width. So you'll see, actually, if you zoom in at the top left corner of the planting plan, there's going to be the planting requirements associated with that. My iPad is reloading. But
It's not just me then.
You got a bunch
every time I try to zoom in on it,
Same problem.
You got a bunch of hollies and azaleas being put in there too.
Mr. Chairman.
Yes.
Are you done? I'm sorry.
Almost.
Oh, go ahead. Keep going. Sorry.
All right. So I guess the long and short of it, though, is the special condition that staff is requesting is to install a 6-foot fence along the back side of the property, and that would be in addition to the landscape buffer that's there as well?
so the condition is actually for the east side, not the south. Yeah.
Okay.
Since they've asked to basically eliminate the 8-foot vehicular use buffer, to put some sort of screening in lieu of landscaping along that east side where they're having some parking.
Okay.
But that is not a condition. I believe there's an existing fence back there. But the applicant can confirm, and they may have some more information if they're planning to do anything to that.
Okay.
With fencing.
I think that's all I have for the moment.
Any more on the right? On my left, excuse me?
I do have a question.
Go ahead, Mr. Williams.
For staff, the back bays that they want to put some bays in the back, is that facing the residential neighborhood?
Yes. Yeah, and on
How
the
far is it?
landscaping plan, you can actually see a good, if you look at that page, you can see another depiction of the footprint of the building, and there's no, one more, Jenny. Yeah, that one. Nope, that one. Mhm. So the property is turned.
So the back is to
So
the left?
yeah,
I think north is this way. Northeast.
yeah. So Jenny, if you'll point at the end of the building,
This
I
here?
can't see it from
yeah,
that.
right there.
We can't
The other
see
end.
it from the other
I
side.
can't
They
see
can't
it.
see it from that side.
Are you talking about the left or right, down or up?
The top part of the
Is that the back?
building, yeah, the top part of the building on this page. You can see the lifts and the orientation of the doors on both sides. And that's an extension of what exists now.
Okay, and what's separating those bays from the residential houses, and how far away is that from the residents? You know?
Yeah, yeah, so there's some, you can see on the right of the building, you'll see some stacked parking for their inventory. And then beyond that, there's the 25-foot buffer with the landscaping planned in there. So, yeah.
Okay, thank you.
Mr. Marchant?
My question was related to the existing fence to the east, which is the back of the property. So I guess we'll let the applicant address that.
Good question. Any more questions to my right? Yes, sir.
I reviewed it appeared to be a well-written letter from Ryan Burkhart in a letter in opposition stating that it was related to the parking, loading, and vehicular uses. This property was in non-compliance with the law, and specifically 9.4.3. Could you address that?
Yeah, sure. So this property has gone through site plan review. This will be the fifth time. The current time is the fifth time. They went in 1998 as the straw market, and then 2002, I believe that's when it transitioned from the straw market to a dealership, not this dealership, but a dealership. And then in 2015, let me see. Yeah. And then in 2015, they did an expansion for Kia. And then 2020, they did Remile, but that one expired. I think they're the 2020 plan.
Have they historically been in compliance or non-compliance with zoning?
Well, so I'm not sure about the 2002-3 timeframe, but I know they didn't get a variance. I did research that. There was not a variance for a buffer or anything like that. It did go through site plan review. I know the ordinance changed a lot between 2001. 2006 was a really big update. So I don't know exactly what the land buffer would have been at that time, or if it was oversight of somebody reviewing. It's hard to know. It's so long. But that's all I can get from my research, is that they did not get a variance.
I'm sorry?
They did not ask for a variance or get a variance.
All right,
So,
thank you.
Okay. Thank you, Ms. Working. Gentlemen, the applicant present. Please state your name and address for the record, and please tell us why we should approve your application.
Hi, my name's Kelsey Santiago from Hussey Gay Bell, 474 Wando Park Boulevard, Mount Pleasant, 29464. And I also have several members from the Lee Motor Group.
So let me stop you right quick.
Yes.
Let me just ask the general question. Do you want to try to entertain all three at one time? I particularly would prefer you start with 37, address the concerns with the tree, and then move your way forward. If you choose to do otherwise, that's fine. But I can combine all your time together, or you can take them one by one. Choice is yours.
I can take them one by one if that's easy. If that's what the board wants to do.
I'm trying to make
then-
it easier for you.
Okay, yeah, we can take them all one by
All right.
one.
All right.
So the 30-inch live oak tree is in the rear of the property. And right now, it has significant encroachment around it. It will be impacted during construction to 56%. And then, sorry. During construction, it'll have the most impact to remove the gravel that's currently around it. It's almost 100% impacted currently. Sorry, I've got my notes mixed up. So once the plan is to remove the gravel in that area and to reestablish kind of a landscaped island that would typically be around a tree that would be saved, such as this one. And that will bring the encroachment down to 56.9%. And the gravel that's around it is essentially acting similar to asphalt. So we're increasing that island area for the tree to be preserved. A certified arborist did the tree survey for the site. We have those records. And based on staff's recommendation, and if approval was granted and conditional with the conditions, they would obtain that same arborist who did the tree survey to be the arborist on site and monitor that and all the other trees on site during construction.
Okay. I'll ask, you finished with your,
Yeah, for the tree
For the tree?
specific one, yes, sir.
so what's the grade of the tree?
It is, it's a grade B tree.
Any other questions regarding the tree, board members? Mr. Marchant?
Thank you, Mr. Chairman. Ms. Santiago, based on your testimony, it sounds like you're creating a better environment for this tree to survive. Is that fair to say?
Yes.
Okay. Did you also explore impervious paving around the tree at all, or are you going back with, pervious paving near the tree, or is everything going to be concrete or asphalt in the new parking areas? I mean, was that ever a consideration?
Double checking.
Ms. Working, could you pull up the map where the tree is located in the aerial, please?
You've basically got about two, it looks like 2 parking spots and circulation drive, right? If I'm looking at the right tree, I hope I am.
Right, yeah, and that is all proposed to be regular, either heavy-duty or standard-duty asphalt in those
Okay.
areas.
And you feel like this tree has a high degree of survivability based on the modifications to the site?
Yes, I mean, based on us giving it that landscape island back to, and giving it more green space, that would be the hopes for that tree. And again, we'd have the arborist on site monitoring it and provide suggestions or recommendation during construction if he saw other remediation requirements necessary.
Any questions on my left? Any questions back on my right?
No.
Okay. Let's go to 38.
So 38 is for the reduction in the perimeter landscaping along the east buffer, which is by the self-storage units to, I guess if you're looking at it, the right side of the plan. There will be a 2-foot landscape area in that. That's what's being proposed to be left. Sorry, let me get to that plan. That is proposed to be inventory parking for the Kia dealership, and there's tree protection. Actually, you can vaguely see it. May I have the laser pointer? Is that allowed?
Can't see it. I don't know, you might be too far away.
Yeah.
Oh, there you go.
So in this area, I can put it on this screen. Whoops. And then like in this area, there's current live oak trees that are being protected. So due to the protection of those trees and also meeting required landscape island buffer or landscape island requirements that the county has, it's kind of pushed us into that 8-foot vehicular buffer along the east side there next to the self-storage units. And there's several vehicles that are being parked on that. Again, that was the old parcel. That was it was a car wash that was demoed and is currently being used for inventory parking. And based on this layout, it will be actually reducing inventory parking to meet the requirements and also save those trees in the middle of the site. And we looked at staff's recommendation, and the applicant owner is willing to put up the 6-foot opaque fence along that property line in lieu of the buffer.
Any questions? Mr. Williams?
How you doing, ma'am? My question is about this, the 8-foot buffer. Staff mentions that due to your redevelopment, you could meet that criteria for 8-foot buffer. Why aren't you able to meet the criteria? Why can't you do the 8-foot buffer?
Like I mentioned before, due to the trees kind of in the center, like in the middle points where I pointed out, there's tree buffer encroachments that we did not want to impact those encroachments and shift the parking over. And then the parking would be limited in those areas if that buffer was not granted. And like I said, there's currently, I believe, 110 cars parked on that side. This would bring it to 95 parking spots. And if those additional parking spots were lost, that would be 30 more spaces. So it'd be 65 parking spots on that lot, I believe. And again, we are, we're moving a lot of parking on other areas in the site to try and work and fit a plan that is up to date with county regs. I know, as she mentioned, that the car dealership was done in the early or the late 90s, early 2000s, and the variances were changing a lot. So we're working on bringing it up to current standards, but also still meeting inventory needs as well.
So as a follow-up, is the criteria number 6, the need for the variance is not the result of the applicant's own actions. Staff mentions here that it's you could meet it because it's your development. You are the ones who are building, making this development, and the parking. You can keep your current parking. You have less parking. Why not keep your parking? I'm just kind of going criteria.
So you're saying
we have to
leave-
meet 7 criteria here, so I'm looking at number 6 here. Criteria number 6. Help us
There's-
understand how you meet criteria number 6. Because you're the one developing this, as according to, at least staff mentions this as well.
Sorry, where's?
Because we have to go through all 7, and they have to meet all 7 criteria
Yes, sir.
for the board there.
There's actually current asphalt running up to the property line out there. So we're bringing the parking off of that buffer, or off of the property line, and creating a 2-foot buffer. And again, we would propose having a fence run along that portion of the property line.
I guess my last question would be, did the county notify you that you're not in compliance on that side right now?
They're not aware. Of
Okay,
that.
that's what I'm wondering. Okay, thank you.
And that asphalt was all the way up pretty much to the property line, I believe up to the property line when that was the car wash in the early 2000s.
What is that property currently now? Is it still a car wash, or is it vacant, or
It's,
who owns it?
it's part of the dealership. The lot is all combined into one parcel, but it's, I think, again, that happened in the early 2000s. And the asphalt never changed where it was then and is currently now.
Mr. Chairman.
Okay, Mr. Marchant.
Thank you, Mr. Chairman. Ms. Santiago, I want to follow up on Mr. Williams' questions about parking. And Ms. Working, if we could go to the sheet right before, I think it's the one right before this one, which is C201.
Oh, sorry.
Yes, that one. So on the upper, since north is really, well, on this one it's up too. On the other one it's up. Oh, well. On the right-hand side, upper right-hand side, which is the property line that we're talking about for this variance, you've got double stacking of inventory, correct?
Yes.
You mentioned earlier you've gone from 110 to 90.
95.
Cars on site for inventory. Boy, these things aren't working that great either, are they? What's going on tonight? We got some weird technology. Anyway, can you talk a little bit about the dealership's storage of cars? Is there any off-site storage of inventory?
I might need to bring the dealership folks up here.
File later, but I think what I'm struggling with, to underscore what Mr. Williams, where he was going with this, is there a hardship that you have to request a variance for the setback or not? And if, for example, if there's off-site storage of inventory, then why can't we meet the buffer requirements on the right side of the plan and just store those cars off-site? I mean, that would be a logical thing to do. And I think the challenge with, are you creating this problem, which is criteria number 6, is something I'm also struggling with as it relates to this particular variance request, because it just seems like, well, we want to store more cars, so therefore we're asking for asking to go within 2 feet of the property line. So help me understand that, I guess, better.
The other I'll let them speak to that more. I know the drainage is also in this area. So if there was a planted buffer above any of the drainage structures, that would be conflicting in that area too. And just because of the existing nature of the two buildings on site and the retention of those trees, the existing live oak trees it limits sometimes where we can put the drainage, underground detention drainage as well.
So your current underground detention is underneath the double-loaded storage of the cars, and that is how many feet below grade? I mean, I can ask the question the other way, which is, you're saying, that you're testifying that the underground detention prohibits you from growing vegetation above that.
Yes, sir.
Is that what you're saying?
Yes, and it, yeah, I mean, the manufacturers don't allow for that. It's approximately 5 feet, depending on where you are on the site. But yes, that would be,
So you can't grow a bush in 5 feet of soil.
I would have to coordinate more with the manufacturer if that was allowable, but typically they like to limit the landscaping around these underground detention structures due to damage of the structures. Yes.
Yeah. Thank you.
Any more questions on my right? On left? Okay. We got all questions out of the way for 38.
Well, one last question. Do you have that underground retention plan anywhere?
I believe we submitted the whole site.
Retention bond plan?
I don't know if it's in, you can kind of see here. And we've actually are in the process of growing where these trees are close by, growing those areas around the underground detention. And so that's going to, again, kind of push the underground detention areas out more. But yeah, there's not allowed to be too much planting within the vicinity of that.
But you already said there's like oak trees around there, right?
Oh, this was, this is being worked on with staff in our current plan, so those areas are expanding.
You said there's currently oak trees on that side,
There's oak trees
on the same side?
here and here. So it would expand out a little bit here and here.
Okay, I'm just trying to follow the logic. Thank you.
Yep.
Good question, Mr. Williams. Good question. Okay. You ready to move to 39? Are you finished with 38? Do you have any other? Go ahead, Mr. Nelson.
Sorry. Ms. Santiago, thank you so much for your testimony. So if I'm understanding you correctly, your argument for criterion 6, and this is not the result of the applicant's own action, is one, the oak trees that are somewhat roughly in the center of the property combined with the need for underground stormwater detention are really what's causing you to encroach upon that 8-foot setback.
Yes, just this is the best area of the site for that underground detention, and to preserve the buffer around those trees in the center area that I pointed out. Yes.
For the stormwater side, is there currently any stormwater management on the property?
There's yeah. There's currently a pond in this area of the property, which is proposed to be removed, and then everything will be going to, including well, actually, no, this site will be treated separately. But everything from this site will be going to that underground detention system over here, and then treated before released into the DOT right-of-way on Highway 17.
Okay. All right. So you're basically upgrading the overall flow of stormwater across the property along with your other improvements to the site?
Yes, sir.
Okay. All right. Thank you.
Yeah. To meet today's standards, again, since this was a dealership several years ago, we're bringing everything obviously up into today's standards.
Okay.
Any other questions? You finished with 38?
Yes.
Okay, let's work on 39.
All right. So then 39 is the addition of the screening of the service bays. This, kind of where my cursor is, sorry about the shaking, is where the existing building stops. I can point it on this side too. That's like kind of right in between the text is where the buildings, like that little faint line is where the current building stops. And then the additional bays are being requested. Again, because of the building being built back in the late or early 2000s, it was orientated in this direction. And we're just proposing to, we're not proposing to do anything to this building or the current service building except for adding those bays. I mean, there'll be interior work done, but no like moving of the buildings. Those two existing buildings, just the addition of the service bays. And there is a group of trees being left in the 25-foot buffer here, which are two grade B trees, one grade C tree, and one D tree. I believe one of them's like a 13-inch, sorry. One's a 16-inch live oak, one's a 15-inch water oak, 7-inch water oak. So there's some established trees that we're proposing to leave, and then the creation of the 25-foot buffer along the back area there behind the service area parking.
Okay.
And again, this is similar to that other request, the need for their operations to pull through the bay doors is why the existing is orientated like that, and then propose to have the usage of both door accesses.
Ms. Santiago, thank you. I know this is can be an arduous process at times. It makes sense to me that you wouldn't reorient the building on this property if you're just simply extending an existing structure and adding some bays to it. But along with that, can you go into a little more detail about what you're doing to screen the backside of the property so that the neighbors don't experience the negative impacts that they've expressed in the letters that we received?
Yeah. Yes, sir. So like I said, the existing trees will remain in that area. The landscaping plan will add several additional plantings. And we did read all the letters of the adjacent property owners, and he would be open to installing a fence along their portion of the property line to provide additional screening in that area, whether it be the same 6-foot opaque fence that is a condition of the east side buffer, or whatever other type of fence staff might recommend.
Okay. Yes, sir, Mr. Marchant.
Thank you, Mr. Chairman. Ms. Santiago, that's exactly what I wanted to ask was, is there an existing fence? Sounds like there may not be.
There is on the adjacent HOA property
Okay.
owners.
I gotcha.
And since that's on their property, they would like to build their own fence on their property.
Sure. So I don't think staff recommended to build a fence under this, on this side of the property, but you would be willing to do that. You're saying your client would be willing
Yeah,
to.
we've read all the letters, and based on the feedback from the community, we would be open to providing a fence
Thank you.
in that area.
Any more questions on my right? Mr. Sedell?
So,
Yes, sir,
quick-
Mr. Williams.
Quick question, ma'am. So there's already currently bays facing to the back, and your request is to add some bays to your additional add-ons?
Yes.
Okay.
Yeah, if you,
How many-
on that plan, like, you can see how there's like darker gray on, here, I can do it on your side, sorry. Like right here, the darker gray, those are the additional bays that are being extended off of that existing building.
The existing building?
Yes.
Okay, thank you.
Okay. Any more questions? Did we drag you out long enough? Okay.
I
Yes,
do
sir.
have just-
Yes, sir.
What is on the side we were just speaking about, what is the width of the buffer? I can't tell from
25 feet.
25 feet?
Yes.
Okay. And the fence would be placed where? The fence that you said you would agree to place?
Behind the plantings. I mean, that hasn't been fully discussed. There is a current fence that runs just inside the property line of the neighborhood. So whether another one's built up, it would make sense to build it right along the property line on the Kia side as well, so that the plantings won't be in the middle of two fences.
So maybe 1 or 2 feet inside the line and then with the
Yes, sir.
remaining being buffered landscaping?
Yes, sir.
Okay. Thank you.
Okay. Any more questions? Don't give the board a chance to go through and just take some wild shots if you have to, 37, 38, and 39. Any questions? While I have her up there.
You're getting a rebuttal, right?
Any questions? Thank you so very much for your testimony.
Oops, I'll leave the.
Good job, yeah. So do we have anyone else to speak in favor of this application? 37. We're going to talk about the trees, I guess. Well, no, I guess to make it easier for us, we're going to try to combine all three of them. Just let us know which one you're talking about, okay? In favor, yeah. Please state your name and address for the record, please, sir.
My name is Travis Bedingfield, address 2800 Deerfield Lane, Wilson, North Carolina. I am here as the applicant on behalf of the owner, John Lee, Harbor City Investments. Everything we are trying to do on this site is to improve the site all the way around and bring it up to standards. So drainage, the tree, we're trying to protect the tree. We're trying to bring the drainage into today's standards. The underground detention will help, but through doing all these things, it's limited how we can operate. Meaning that we have certain parameters we have to keep for manufacturers. And basically, we're just trying to improve the site and just make it better for us and the community. The buffer we are requesting on the east side, as Kelsey mentioned, we have limited restraints. We're already through this design that we are doing, losing a lot of spaces that's going to impact us operationally. And I heard your question about off-site storage. That would affect our operations, how we maintain and sell vehicles, having to go somewhere off-site to get them and bring them back. Could it be done? Absolutely, it could be done if we could find the correct property and it was affordable which is hard to do in these days of time, as we all know. But like I said, just back to a lot of when we're talking about the bays, those bays have been existing long before me. I've only been with the company a couple years, so those bays were existing for a long time, have been operating in that way. I know some of the letters brought up lighting. Lighting is going to be addressed throughout this whole plan. We will be putting in new lighting fixtures that'll be LED, directional. They'll have screens on them to push the lights over into our property to not bleed over into the neighbor's property, which is doable with new technology. So that's all I've got. If anybody's got questions for me.
I'm going to let Mr. Martin start. Oh, wow, okay. Any more questions on my right? My left?
Well, I'll ask one just for fun.
Hey, having fun.
One, did you say you're from Wilson, North Carolina?
Yes, sir.
All right, I used to live in Kinley, North Carolina.
Oh, did
so,
you?
Yeah,
Okay.
yeah,
Right down the road.
long time ago. Anyway, what does Kia require for a dealership in terms of the ability to store cars, the number of cars? Is there any type of requirement?
They do. They have. I don't have the number with me. I'm sorry. They have different requirements depending on the size of the dealership, the volume that the dealership pushes through in a year. What that number is, I can't remember off the top of my head. I'm sorry. But I do know that I don't even think we're meeting that requirement, but they know we have issues that we're trying to work through, so they're being a little lenient with us, but it's kind of a fine line to walk.
Well, that's helpful to know if even with the changes that you made, you don't meet their minimum requirement.
Right.
So, thank you.
Okay.
So what happens if you can't meet those parking requirements or storage requirements for your vehicles?
There's a lot of talks, and you hope they give you some leniency, but there's no guarantee. If not, then we'll have to come up with some other plan, or I don't know how they'll penalize us. Probably in production vehicles they let us have and stuff like that.
Okay.
Yes, sir.
Well, hold on. Any other requirements that you have to have or that Kia places on you guys?
Oh, they replace a lot of requirements from everything. Oh, I'm sorry. They replace a lot of requirements from size of lot to number of vehicles to size of building, which they've already allowed us to reduce that size of building. They even have requirements that they tell you what kind of furniture they want you in your building. So,
Mr. Williams?
Yes, sir. My question. I like you saving the oak tree. That's awesome. You know, my question is concerning that buffer. Once again, are you meeting the parking requirements now?
are we meeting
The parking requirements that you have currently? Because you're currently a Kia dealership, right?
Yes, as far as I know, we are meeting the old requirements. They have new requirements. That's why one of the reasons we're updating. So we are meeting the old requirements, but we are losing spaces through this new requirement, bringing everything up to standards.
Okay. Are there other possible plans to where you could meet the county's requirements for the buffer?
That gets back into where Kelsey was speaking, that due to the underground retention and where we have to place it and the trees that we are saving, how it's just limited space. I mean, I don't know of any other way we could do it without losing. And if we lose that buffer, as she said, we lose like 30 spots. So, which is a big percentage of the number of spots we have.
Okay, thank you.
Thank you so very much for your testimony tonight.
Thank you.
Do we have anyone else to speak in favor of this application? Do we have anyone to speak in favor of this application? At this time, do we have anyone to speak in opposition? All right. Please state your name and address for the record, and please tell us why we should disapprove this application.
My name is Tim Rudy. I live at 2355 Lantern Street. That's part of the Ashley Preserve. That's the neighborhood directly south of the Kia dealership. And I'd like to say I'm with my neighbors here in conditional opposition.
Conditional opposition.
Well, I mean, we just heard this evening they're looking at the possibility of building a fence on the south boundary, which borders Ashley Preserve, and that would be a wonderful step in the right direction. I do have a prepared statement, so I might just go through that, if I may.
Please.
Ashley Preserve was developed by Stanley Martin Builders in 2019. As I said, it borders the southern boundary of the Kia dealership. We want you to know that we believe Kia needs to take proper ownership for screening their commercial property from our residential community. County ordinances in support of this argument are quite numerous. Section 9.4.1 states in part, when modifications or additions are proposed that would increase the number of parking spaces, the area of vehicular use areas or gross floor areas of buildings by more than 25% above existing, the entire parcel shall be brought into compliance with all applicable standards of this article. 3,200 square feet is above the 25% limit. So the entire parcel technically needs to be brought up to complete compliance with code. Section 9.5.2E4. Buildings shall be oriented so that the loading area shall not face residential districts or uses, existing rights-of-ways, or from planned future rights-of-ways, except for properties within the IN district or for safety services. Interestingly, loading areas may be oriented toward adjoining developed properties which are commercially zoned or toward adjoining properties eligible for future commercial development if and only if they are screened from view by the use of fencing or walls which are compatible with the overall architectural scheme of the project. I find it interesting that the code says a commercial property must screen a commercial property, but it doesn't say it has to screen a residential property in this section of the code. The issue we have here is that Kia apparently did not have a variance in 2003 when the service building was constructed. That's the building they intend to expand. And if they had a variance, or if they didn't have a variance, there should have been a screening requirement, in our opinion, put in at that particular time. It was tract X in 2003, a wooded lot, so we don't think that should have kept Kia from building at that time, a screen from a residentially zoned area. In addition, we note that staff has recommended a 6-foot fence be built on the east boundary. Well, there's no mention of a fence on the south boundary, although there has been this evening on the part of the applicant, and we appreciate that. As far for us, our perspective, the storage facility on the eastern boundary doesn't need to be screened. There's nobody living there, but we are, and we should be screened at Kia's expense for building and maintenance of the fence. Then section 10.2.2 expansion says a non-conforming commercial or industrial use shall not be enlarged or expanded unless one of the following conditions exists. A, such expansion eliminates or reduces the non-conforming aspects of the situation. I read Kia's application, and I think they're honestly stating that they're not operating in a conforming manner. They admit that asphalt parking exists within the entire required 8-foot landscape buffer, and their request for these variances is meant to help them comply with that part of the code. I thank them for their recognition of the present non-conforming conditions of the property. However, I disagree with their base argument that since they were existent prior to the development of Ashley Preserve, their non-conformance should somehow be overlooked, excused, or accommodated. Lastly, 3.1.9 conditions of approval. This decision-making body has the authority to impose conditions of approval as allowed by law. Conditions may be those deemed necessary to reduce or minimize any potential adverse impact upon the property in the area or to carry out the general purpose and intent of this ordinance. To that, I say you, as a decision-making body, have the ability to place proper conditions on Kia's use of their property to reduce adverse effects on Ashley Preserve. These conditions, from our perspective, would be the following. In addition to or instead of requiring Kia to build a 6-foot screening fence on the eastern boundary, make Kia responsible for an 8-foot screen on the southern boundary that they own and maintain. I think I heard them actually admit that they would do that. That's a great step in the right direction. Number 2, allow no reduction in the required landscape buffer less than 5 feet. ensure that the overall site plan review of the Kia property includes proper stormwater drainage so as to ensure the Kia practice, which is happening now, of pumping water through our property, is discontinued. And I think I heard something about that as well. And lastly, ensure that the site plan review ensures compliance with lighting and noise ordinances. I think they all addressed all those things, but I wanted to bring them to your attention because that is what myself and our neighbors wanted to make sure happened this evening, and I thank you for your time.
Thank you so very much. Hold on, let's see if any board member has a question for you. Start on my left. Any questions? Yes, sir, Mr. Nelson.
Is Mr. Rudy? Is
Yes.
That, well, appreciate you taking the time and expressing the neighborhood's concerns. I don't know if you're speaking on behalf of everybody or if we'll have some others step up as well. But
There might be one or two others.
okay. The one thing that I wanted to point out and make sure the neighborhood understood is that on your side of the property, on that south side of the property, there's actually a 25-foot buffer that's being installed by the dealership, and they're also saying they would agree to the fence as well. Are y'all clear with that?
We
part of
understood
the
that
plan?
from the meeting tonight. That was news to us.
Okay, all right. So I just wanted to point out there's a little bit more going on than just putting a fence there. The 8-foot setback is actually, or the 8-foot vegetative buffer variance request is not on your side of the property, and that variance actually would have little to no bearing on y'all's property.
Understood. Right now, they're parking right up to the fence as it is. There is no 25-foot of anything on the south side. So, I mean, from our perspective, if they put up the fence and you could see to give them even more parking space there to accommodate their needs as a Kia dealership, we wouldn't necessarily be opposed to that.
Well, hopefully a lot of the information you guys are hearing tonight will help and aid in your understanding of their goals of the project and can meet some common ground here. So that's all.
I think
all
that's
have.
what we're here for.
Thank you, Mr. Nelson. Anything on Mr. Marchant?
I may be wrong, but I'll ask staff to confirm this. But well, first of all, thank you, Ms. Rudy, for your comments. And I for one agree with installing the fence on the side of the property that abuts the residential. So if I were to make a motion, I'd make that as part of the requirement. But I do have a question about our purview as a board as it relates to lighting and some of these other things you brought up. It sounds like the applicant is willing and planning to mitigate light pollution in your neighborhood and also to accommodate as much as they can the stormwater retention as required by code. But we have limited purview around that. I think that's true, and somebody correct me if I'm wrong. I just want to say that because I want you as someone opposed to some of these things to understand that we can't require applicants to do everything. So
That's understood, but
Yeah.
that maybe helps staff make sure that the site review is done appropriately.
is that correct, staff, attorney, right, what I said?
Yes. Without knowing all the building code standards, it would be.
Thank you so very much for your testimony.
Thank you.
I got a question.
Oh, I'm sorry. Please hold on. Mr. Jordan,
How many residents you have with you tonight?
How many are here tonight?
how many representatives do you have here with you tonight? Show of hands,
Representing
two.
1, 2, 3, 4, 5 households.
Thank you.
Thank you, Mr. Jordan. Thank you so very much for your testimony tonight. Yes. Do we have anyone else to speak in opposition for this case? Do we have anyone else to speak in opposition? Very good. You now have the opportunity for the right of rebuttal, if you so choose to. Please state your name and address for the record.
Good evening. My name is Elizabeth Schminke.
One more time, because you were not speaking.
Sure. Good evening. My name is Elizabeth Schminke. I'm the architect with Hasige Bell on this project. We are at 329 Commercial Drive in Savannah, Georgia. I just wanted to comment on a couple of the items that the neighborhood has brought up. One of which was the lighting, which we actually did receive comments about. The Kia requirements are higher than what Charleston allows, so we have actually modified those to meet the requirements. So that shouldn't be an issue. And again, they're very directional, and should meet the requirements as outlined by Charleston County. Absolutely, we are 100% in support of placing a fence behind. We're happy to be good neighbors. I know that the ownership team really wants to be considerate of that, so that shouldn't have a problem at all. And I think the other aspect was the drainage, I believe, which I think we've already addressed that. So the request really for the screening, we have no issues with that. So I just wanted to make sure I addressed the lighting.
Okay, one moment, please.
Sure. Absolutely.
Mr. Stadell has a question for you.
Thank you for your testimony.
Sure.
Just clarification, when Ms. Santiago was speaking, she mentioned that willingness to put up a 6-foot fence. The neighbor is asking for an 8-foot fence. There was just a discrepancy there, and I wanted to see if there was an issue with an 8-foot fence versus a 6-foot fence.
No, the 6-foot fence was what was outlined by the county, but we can certainly leave that up to you as a board if there's a preferred one. 8-foot is a little tall sometimes, but if that would be the preferred one, I don't see any issue.
Okay, thank you.
Any more questions on my right? My left? Mr. Jordan?
As a follow-up to what my colleague just said, to me personally, this seems very, what's the word? Exciting, maybe, that you have the applicants and also the residents in a spirit of wanting to work together. So why not the 8-foot fence, since y'all seem to be so close to getting the approval?
Certainly. Yeah, we read all of that. We're grateful for active neighbors, and we're grateful for those letters. It was very informative and helpful in creating a plan that we can all meet.
But are you willing to do the 8-foot fence?
As long as the site plan approval process will allow it.
Can I take it as a yes?
Yes, we'll do our very best, absolutely. Our intention is to create an 8-foot fence so long as the county can.
I mean, if you haven't noticed, I see some smiles back there.
Yeah,
so
sure.
2 more feet might go a long way.
Absolutely. We have no objection to that. We just have to make sure it goes through the site permit process.
Any other questions on my right? Thank you.
Yes, thank you.
At this time, this case is closed to the public. Board members? Any more discussion, questions? Staff? Of staff? All right, gentlemen, I need a motion. Let me clarify. We have 3 requests in front of us. One person can do all 3, or we can divide it up. If you're willing to make a motion to either approve or deny, please let us know at the very beginning. Okay? So at this time, do I have a motion to either approve or deny? Please.
I'll make a motion, Mr. Chairman.
Okay. Are you going to tackle all 3, or are you just going to do one?
Yeah, I'll give it a rip. That'll be
Okay.
fine. For case BZA-12-23-007337, I move to approve, as I believe the applicant has met all 7 criteria. Criteria number 1, there are extraordinary and exceptional conditions pertaining to the piece of property. I mean, the existing conditions are, in the case of this tree, are and not in the best interest of the tree, and I find that the applicant is trying to take an extraordinary condition on the property and improve it so that the life of the tree may be improved and hopefully live a good, long life. Criteria number 2, these conditions do not generally apply to other properties in the vicinity. Based on the testimony and the review of the adjacent properties, it doesn't seem like we have a condition like this, and so it certainly is out of the ordinary and meets this criteria. And criteria number 3, because of these conditions, the application of this ordinance to the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. I think we heard during the testimony the challenges that the applicant has as a member of the Kia family and greatly reducing the on-site storage of the cars. So in doing that, the applicant's been creative at designing the site to accommodate that and also save this tree. So I believe it does meet that criterion. Criteria number 4, the authorization of the variance will not be of substantial detriment to the adjacent property or to the public good. Again, saving a tree is great for everybody and will not be a detriment to the surrounding properties or the public good. Criteria number 5, the Board of Zoning Appeals shall not grant a variance, the effect of which would be to allow the establishment of a use not otherwise permitted. That is not the case for this criterion. The use is already permitted and being continued under the zoning, so it meets that criterion. Criteria number 6, the need of the variance is not the result of the applicant's own actions. In fact, the applicant is taking great action to save the tree, and so in this case, the action is to benefit the site and benefit the tree. And criteria number 7, granting of the variance does not substantially conflict with the comprehensive plan or the purposes of the ordinance. In addition to meeting the 7 criteria, the applicant shall also meet the approved recommendations by staff as submitted in the staff review, all 4 recommendations. This ends my motion.
Do I have a second? Okay, Mr. Williams down there with a second. All right. I'm just going to stop here with any discussion on this application. Any discussion?
Well, like I said, the tree being saved I'm for it.
Okay. Call for the question. All those in favor, please indicate by saying aye. Aye. Raise your, okay. That one is unanimous. Good. Keep moving forward.
All right. In case BZA-12-23-00739, I move.
3-8.
I'm sorry, 3-8. Let me back up because I don't want to mess this up. 3-8. You want me to state that again? Do I need to state that again? Are we okay?
Yeah.
3-8. Okay. I move to approve the application as I find that the case meets all 7 criteria. Criteria. Number 1, there are extraordinary exceptional conditions pertaining to this particular property. As stated in the last motion, the requirement of parking and also the requirement of stormwater retention is certainly extraordinary, and therefore the applicant's request of a variance for the 8-foot buffer makes sense, and I believe it meets criterion number 1. Criterion number 2, these conditions do not generally apply to other property in the vicinity. Again, as a car dealership in the commercial setting next to a storage site, and the extreme conditions for accommodating trees and under or subsurface retention is not typical of other properties in the vicinity. So I think it meets criteria number 2. Criteria number 3, because of these conditions, the application of this ordinance to the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. As we heard from the applicant, potentially if the buffer were required, the dealership may not be effectively be able to prosper because storage of vehicles would not be possible, nor would we be able to save 2 of the trees in the general vicinity of this area, nor would we be able to manage stormwater. So I believe it meets this criterion. Criterion number 4, the authorization of variance will not be of substantial detriment to the adjacent property or the public good. As we heard from the neighbors, they didn't feel like this part of the site really create any detriment to livability, and we haven't heard from the neighbors of the storage facility next door. So based on the testimony and the findings of the application, it would not be detrimental to the public good or the character of the zoning district. Criteria number 5, the Board of Zoning Appeals should not grant a variance to the effect of which would be to allow the establishment of a use not otherwise permitted in a zoning district. Same use of the property will be continued. Criteria number 6, the need of the variance is not the result of the applicant's own actions. I believe because of the need to save 2 trees and also manage stormwater, that the applicant has some difficult situation and is trying to make the best of it by asking for the variance for this 8-foot buffer. So I believe it does meet criteria number 6. And criteria number 7, granting of the variance does not substantially conflict with the comprehensive plan or the purposes of the ordinance. In addition to meeting all 7 criterion, I find I included in my motion the recommendation of staff, the one recommendation as presented in the by staff. Here is my motion. Thank you. I'm sorry.
8 foot.
No, sir. That will be on the next
Okay.
next one.
Okay.
That's my motion.
Okay. Do I have a second? Mr. Nelson, the second. Questions? Discussion? All those in favor, please indicate by saying aye and raise your right hand. Aye. Any opposed? This unanimous. Good.
Okay,
Last one.
That was 8, right? So this
That
is
was
9?
8. This is 9.
All righty. So we're talking about the,
Bay doors.
what are we talking about?
The bay doors in the back.
Bay doors. Thank you. Thank you very much, Mr. Williams. All right. BZA case -12-23-00739. I move for approval as I believe it meets all 7 criteria. Criterion number 1, there are extraordinary and exceptional conditions pertaining to the particular piece of property. As we heard in the testimony, we had an existing building that had, I think, 5 bays on the existing building, and the applicant is extending that building by 4 bays with the addition of the service building. And also, I think what's extraordinary is that building has been in place for quite some time, and the neighborhood is about 5 years old, if my math is correct. So the extraordinary and exceptional conditions are that the existing piece of property with the existing building already housed bays that face the residential property, and the natural extension of that building makes a lot of sense. And so I think that's extraordinary and exceptional, and so I think it meets criteria number 1. Criteria number 2, these conditions do not generally apply to the other property in the vicinity. Again, as has been said in the last 2 motions, this is a car dealership that's not necessarily in the same vicinity as adjacent of the same kind of use in other properties, and also because I don't believe we have any bays facing residential areas from adjacent properties. So this does not generally apply to other property in the vicinity. So I do believe it meets criteria number 2. Criteria number 3, because of these conditions, the application of the ordinance to the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. As we heard in the testimony, if the Kia dealership is going to come up to today's standards and be able to grow and accommodate the sales and the maintenance of cars, it's required that they expand. And so if we weren't able to grant this variance, it would effectively prohibit or unreasonably restrict the utilization of the property. So I believe because of the variance, it meets criteria number 3, variance request. Criteria number 4, the authorization of the variance will not be of substantial detriment to the adjacent property or to the public good, and the character of the zoning district will not be harmed by the granting of the variance. I believe, based on the testimony of the applicant and the neighbors and the willingness to build an 8-foot fence, that this will mitigate, and the 25-foot buffer that's required will mitigate the otherwise harm that the bays might require from a visual or even acoustical standpoint. And as I will add that to the end of my motion, I don't believe then that the request of variance to have bays facing the residential neighborhood will be detrimental to the public good. And so I do believe it meets this criterion. Criteria number 5, the Board of Zoning Appeals should not grant a variance, the effect of which would be to allow the establishment of a use not otherwise permitted. We're not doing that. So it does meet this criterion. Criterion number 6, the need for the variance is not the result of the applicant's own actions. I believe that, again, based on the reasonable expansion of a building that was already being used for maintenance and already had bays, that this makes sense, and any other kind of any other kind of addition on another part of the property would not be in the best interest of the property or the use of the property, And so I don't believe that is a result of the applicant's own actions. And criteria number 7, granting of the variance does not substantially conflict with the comprehensive plan or the purpose of this ordinance. In addition to staff's recommendation of prior to zoning permit approval, the applicant shall complete the site plan review process. I'd like to add a second recommendation that the applicant install an 8-foot fence along the entire distance of the rear of the property in addition to the buffer, to create a more substantial buffer between the residential neighborhood and the Kia dealership, and that staff work with the owner to come up with the appropriate design of that. This ends my motion.
Thank you. Do I have a second? Mr. Jordan, thank you. Any questions? Discussion?
I would like to commend my colleague for making an exceptional motion for this case, for all three of them. Thank you.
Good. I was going to do it afterwards, but okay. All those in favor, please indicate by saying aye and raising your right hand. Aye. It is unanimous. So, lady, gentlemen, community, all 3 applications were approved. Within 10 days, you'll get information from staff letting you know the next steps in the process. Once again, congratulations for working together. I am just really, really pleased, and this board is. So thank you for that, and good night for you. Also, it is a few minutes after 7. We're going to recess for 10 minutes and reconvene thereafter.
He's not here, though.
Okay, thank you for your patience during our brief recess. At this time, next case we'll call is BZA 12-23-00740. And Ms. Working will be doing that one for us. And we have 3 cases, correct?
4.
4, excuse me.
00741,
42,
742, and 43.
Yeah. So thank you.
Okay.
Yes.
The applicant and property owner, Andrew Greenspan of GHP Maine LLC, represented by Jake Serrano of Live Oak Consultants LLC, are requesting 4 variances for proposed commercial flex space use at 860 Main Road, which is TMS number 250000002 on Johns Island. The 16.27 acre subject property is located in the Main Road Corridor Overlay Belvedere Main Commercial BMC zoning district. Surrounding properties to the northeast, east, and south are also located in the overlays BMC zoning district. There's a property to the north located in the industrial zoning district, and the adjacent properties to the north and east are located in the agricultural residential HER zoning district. This is the overlay map. The project is currently in the site plan review process. Regarding the case 1, the first variance is a request to reduce the required DBH number of trees per acre. The second variance is a request to reduce the required minimum 30% of parking spaces that must have a pervious surface and to exceed the maximum 70% impervious surface coverage. The third case is a variance to request to omit or to reduce the required 8-foot perimeter vehicular use landscape area adjacent to other commercial industrial type use, tree islands within the parking areas, and land use buffers, 50-foot type G at AGR adjacent to parcel 036, and 60-foot type H where adjacent to AGR parcel with dwelling on site, which is parcel ending in 135. And finally, the fourth variance is a request to reduce open space and omit foundation plantings. Now, these are the ordinance requirements for each case. The 300-foot radius map and the aerial map. This is the posting for the first case. We did post this property on and visited the site on January 17th, 2024. And we have several photographs of the subject property. The intersection of Belvedere Road and Main Road, and then Belvedere Road on the left and Main on the right. This is the posting for the second case, and the third, and then the fourth case. This is the existing conditions and demolition plan, the site layout and paving plan. This is the demolition plan for the west side of the property, and then the east side, and a layout paving plan for the west and for the east. A landscaping plan for the west, and a landscaping plan for the east, and a plat. So, we did receive letters from 2 people opposing the variances, and those copies were in your initial packet. The variance number 1, we stated that it may meet 1, 2, 3, 4, 6, and 7, and it meets 5. 2, which is the pervious versus impervious surface percentages, we stated it meets 1, 2, 3, 4, 6, and 7, and it meets 5. 3, the request to omit or reduce the landscaping, tree islands, etc., may meet 1, 2, 3, 4, 6, and 7, and meets 5. And 4, to reduce open space and omit foundation plantings, we said it may meet 1, 2, 3, 4, 6, and 7, and meets 5. The board may approve with conditions, or deny the cases based on the BZA's finding of fact, unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, staff recommends the following conditions. And so for the first case, 00740, 1, prior to zoning permit approval, the applicant shall complete the site plan review process. 2, all trees to be planted on site specified on the proposed landscape plan shall be a minimum of 4 inches caliber. The difference in the total inches per acre planted versus the 40 inches per acre shall be mitigated through the tree fund as described in section 926D. And for the last three cases, this condition is the same. Prior to zoning permit approval, the applicant shall complete the site plan review process. Same conditions. Any questions?
Any questions of staff? Thank you, Ms. Working. Gentlemen, please state your name and address for the record, please, sir.
Sure. My name is Andrew Greenspan. My address is Marshgate Drive on Seabrook. And I appreciate that you guys are all volunteers, and I appreciate you taking the time to do all of this. A brief history of the site. You may be familiar with it. It is the former Damari tomato processing plant. It's been abandoned and dilapidated for a number of years. We purchased it in November of &22. It's taken us this long to get in front of you because we are trying to rehabilitate and bring it up to code. It's important to us to bring it up to speed and make everything in compliance. We've done everything we can within our power to minimize the number of variances that we've brought in front of you. I think it's important for you to note a couple things about our strategic plan. We bought the property in part because of the main road zoning overlay. Everything we plan to do with it is consistent with that zoning, while at this point the property is vacant and has not been marketed. We do not intend to market it to anybody outside of uses that comply with that zoning overlay, if that was a double negative. We're only interested in uses that are consistent with the new zoning overlay. We think the property works for that. Our vision for the property is what we would call an industrial or an executive park. We envision marketing it to mostly the community. We believe right now that the industrial and/or what we call back-of-the-house users, none of this space exists on Johns Island. A couple of people who have contacted us, they may live on Johns Island. They need to travel to West Ashley, North Charleston to find facilities, and then back to Johns Island in order to do their work. We think we can eliminate that and provide a much-needed service to Johns Island. I think it's also important specifically for the board that what we're doing here, this is not a new development. We're taking the old tomato sheds and we're trying to work within that framework. So the variances, the reduced buffers, are so that we can keep the existing footprints of the tomato sheds rather than knock them down and start over. And I think that pretty much summarizes what we have. Yes, we've tried to respect all of the existing laws and bring it up to compliance. One more thing on the stormwater. This property has been here, I think, longer than all of us. I've gone by over a couple of the big storms. The stormwater, the ancient stormwater system works quite great, terrific, but again, that's another thing that we're doing, and we're bringing it up to snuff and working with DHEC in terms of DNR, bringing it up to speed. So that's a summary of our project, and we're happy to answer any questions.
Okay, so you're gonna, I guess you have addressed all 40 through 43 concerns that we've had for each case.
Yes, we're here with Live Oaks Engineering, so if you have any specifics about any of the 4 variances, they can answer. If I can't answer them, they certainly can.
Okay. So
But
you've
yes,
given us,
all 4 of them.
so you've given us testimony for all 4.
Correct.
I apologize, I should have asked you to break it down.
Yeah. I don't plan on repeating myself 3
Okay.
more times. Thank you.
Okay, well, thank you. Let's see if anybody over here to my right has a question. Yes, sir.
Thank you, Mr. Greenspan, for your comments. Can you give some examples of the type of businesses that you see going in?
Yeah, sure. Again, we've been careful not to market the property until we get through our site plan approval and all of these processes. think as everybody in this room knows, it's a pretty small community through various of our vendors, suppliers, and neighbors. Two examples of people we're talking to. One is a wholesale supplier for contractors. Like I said, they have locations in North Charleston and West Ashley. So the contractors go to their supply shop, pick up their trade, and then I think for the most part would then feed the Sea Island, Seabrook, Kiowa, and down to Johns Island. So they need 6,000 to 8,000 feet. It's about, they would have a kind of a showroom in the front with glass panel, and they would keep their wares where the contractors would come in with the ticket. I need X, Y, and Z. They would cut the machinery for them, and they'd be on their way. Like I said, I think in our own small way, we're going to cut down a little bit on the traffic on Main Road and 17, because I think a lot of people are going up north and then coming back down south, which I think we can avoid. Another example, a local couple on Johns Island has approached us. They're installers of high-end installations in high-end houses. It doesn't matter specifically what they do. They currently can't find any locations. All of their wares are stored in self-storage facilities. I said to them, wow, that's quite expensive. They said it's not even so much that it's expensive, but every time they get a drop of their inventory, the trucker charges them per pallet. So the idea of having a few thousand feet with us where they can get a loading dock and get the wife was in tears of happiness that they wouldn't have to pay for that drop. So I think those are two very, those are the type of tenants that we're looking to rent to.
Thank you. I got to take a shot. I'll give it back to you. How many tenants do you feel that you can proposally put in this?
Again, we haven't marketed it. We're on a speculative basis. I prefer it be quite multi-tenanted and there be several tenants. That seems to be a better business model for us than a couple large gorillas or 800-pound whatever. So the first user I mentioned to you was 8,000 feet. The second one was closer to 2,500 feet. You know, if we go along that process, we could have a couple dozen tenants, which would be my preference, quite frankly.
Because you're kind of painting with a broad paintbrush here. You have a lot of square footage that you are proposing to utilize. So,
correct.
Yeah. So you talk about traffic, you talk about infrastructure that's there. I'm just kind of hoping that you can give us a little bit better understanding of how many people that you're willing to put in this place.
There's a couple things here. First of all, it is a speculative project. We're investing in it on a speculative basis. It is not pre-leased. So unlike Kia, I don't have an automobile dealer in my pocket. But it's important in terms of the number of people and traffic. We have an existing site. There's 16 acres of pavement. There's 180,000 feet of foundation that exists right there. And it's not so much that I am proposing a large number of people as opposed to smaller, different businesses as opposed to one large business. The zoning and the codes dictate the number of people that can work there, the number of parking spaces. And for example, the small user of the installer, the 2,000 people, they're not even there most of the time. Most of it is the inventory. So please don't confuse several tenants and/or users with a large number of people.
But you are speculating, but you're asking us to speculate as well, and that's not fair.
Well, I think what is fair is that we're playing by the rules. We're getting a site plan approval that limits the use according to the zoning. If we show up with anything that's outside the box, then we're starting over. So, again, this is a vacant, abandoned facility that's sitting there. We're trying to invest our smarts, our dollars, and our expertise to bring it back online and make it a vibrant part of the community. I think the reason why we're doing that is I believe the need exists within the community. So while it's on a speculative basis, it's important to understand we're not speculating the range of uses. All are going to fit within the box. If anything should come in here outside of the box, we understand that the rules that we're talking about tonight do not apply.
Well, okay, but you're here, and, you know, you do have 16 acres in which to work with. Mr. Marchant?
Thank you, Mr. Chairman. Mr. Greenspan, if I understand you correctly, you are trying to accommodate warehousing, distribution, material management for a variety of companies. They could be an irrigation installer that keeps all their stuff there so they don't have to come all the way back to West Ashley to get pipe and fittings and all to go back out to Kiowa, right? Or someone who's in architectural detailing that keeps specialty items out there, so for houses, right? I mean, it could be a myriad of things.
Correct.
Contractors, suppliers,
Correct.
janitorial, whatever, right? So, so in many ways, I kind of appreciate that. I used to be in that business myself, so sitting in traffic for 2 hours to get pipe can be a pain. Can you talk a little bit about the existing conditions as it pertains to pervious and impervious surfaces? I mean, I'm looking at the aerial, and the building footprints are pretty clear. Is most of this stuff gravel, dirt, or is it all paved now?
For practical purposes, the entire site is paved, macadam.
Okay. So that's asphalt.
Some of it is poured concrete where the trucks, I think, used to back up, and I guess when it got hot, they poured some concrete. Okay. But most of it's macadam.
So can you talk a little bit about why you would not want to accommodate the county's requirements for pervious surfaces and plantings and things like that? I mean, what is the hardship by which we have to judge the reason to grant a variance from things like that? I think you're going to have to wait. I mean, just procedurally, I mean, you can defer that question. It's not a problem. I'm thinking more about site use. I mean, is there a reason why you're asking for these variances?
I guess I will defer that to the site engineers. Again, I would stick with my initial comment of we've gone through an inordinate amount of time, not a complaint, a fact, time and expertise and thinking it through. We bought an existing site that really was in disrepair, and we're doing what we can to use the existing footprint and/or infrastructure. Again, another example of a user. They may have been in front of you. They bought some property on Main Road that is currently all trees. They want to cut all the trees down and put a building up. I have a building on pavement. I'd like to rent them space. I believe I can rent them space for less than they can cut the trees down, build a building, and own a building. So I believe we are really providing an opportunity, in our own little way to cut down on traffic because people are commuting, I know for a fact, up and back. And B, I think by taking advantage of an existing site, we have an opportunity to preserve the character of what exists on Johns Island.
Yeah, I have one other question, which is it fair to say that the majority of users of this site will be those that store, house, distribute the property, and you're not going to have the general public coming in and out? I mean, this isn't retail. This isn't...
Correct.
Okay.
Correct. This is not a retail facility. These are not stores that we're talking about.
Okay, thank you.
Yes, sir.
I had a question. I'm looking at the ordinance, and I'm using
You want want me to answer
Yeah.
whatever questions, and then Jake will go?
You know what,
Back and forth?
for
However.
the spirit of time, you may certainly have a seat. Let's go ahead and just get to the,
Go ahead, your question, and then we'll turn it over.
Okay, I'm looking at the ordinance, I'm mindful of the golf term, they say sometimes you have to play them as they lie, whether you like it or not. But I'm curious whether you have or expect to receive incentives, tax credits, you're refurbishing a property. What is, are there any incentives that you're provided to help you with this project?
Yeah, we've been in touch we have been in touch with Steve Dykes, who is very supportive of the property and the project. He put us in touch with Berkeley Electric, that's helping us with the site work. And I believe there will be some applications if we can get there in terms of with the county. Yes, yes, I hope so.
Or thank you.
Nothing has been submitted, but that would be the hope.
any more questions for this gentleman?
Well, he wants to
Mr.
sit down,
Greenspan?
so am I right?
Yeah, okay. Thank you, Mr. Greenspan, for your testimony today. Yes, sir. Please state your name and address for the record.
My name is Jake Serrano. I'm with Live Oak Consultants, 4214 Fellowship Road, North Charleston, South Carolina. I am the engineer of record, and we are engaged by Mr. Greenspan to work on this project. The old tomato shed has been on that property since the 1960s. It was developed at a time where there are no zoning regulations in Charleston County. So the buildings or the sheds were constructed at that time, and the majority of the site were paved with concrete and asphalt pavement. And it has operated in that condition until about, I would say, just a decade before now. So it sat around for not being used for some time. And then the overlay district zoning came in, I don't know, 2 or 3 years ago. So because we wanted to use the existing shed and build the building on the same footprint as the shed that exists now, we wanted to keep also the pavement, which is still in usable condition. And because of that, we wanted to investigate what we can see and still use. However, we wanted to incorporate some of the regulations that are brought about by the overlay district. So one of those conditions is the DBH per number of trees on site. The total requirement is 40 inches per acre. And if you multiply that by 16 acres, we are required to put in 651 inches of trees. So on the front of the site entrance, if you would look at the drawing that is put in for L1-1.2, which is the landscaping plan. One more. There you go. There is a short frontage on Main Street for this site. We will close that entrance on that site. And we are working with the DOT and a traffic consultant to minimize the impact of this site to the traffic. So we are bringing that entrance on Belvedere Road that you can see about halfway through up on Belvedere. That's where we're going to put the new entrance. So not only are we closing the entrance on Main Street, we're also introducing a 75-foot buffer on the site, which we will demo the existing pavement where it exists so we could plant those trees. Now, we've investigated how much trees we can plant on that site, and we are still not able to meet the ordinance that will require 651. Now, the staff has recommended that we use 4 inches as opposed to the 2.5 inches that we originally looked at, and that would increase the number of tree to satisfy closer the requirement of the ordinance. And whatever the balance is, say we have, we can provide 400, just giving a number. Whatever the balance is, we will pay that impact or excess in a tree bank. And I think that's been noted in the condition, and we're in agreement with that condition. So that hardship invariance request is essentially 040 of our application. The next one is 741, which is the minimum 30% parking space have pervious requirement. That was introduced in the overlay district, and we want to see if we could get an exemption for that requirement, because it doesn't make sense to do that now and still be able to use the existing pavement. Maybe if we are in a process of rehabilitating the existing pavement, we can certainly do that. Now, we've worked with the public works staff, and they ask us to put trees, because we also asked for a painted island on the exterior of the parking. The parking areas, if you would notice, the ones that are closer to the building, they have trees, and we are inverting the islands so that stormwater can get into those islands. Now, those are requested by stormwater staff, and we are abiding by that. So, again, the request for the hardship on 741 is to see if we could eliminate the pervious surface requirement and exceed some of the 70% impervious surface coverage, because it's an existing facility.
Could I ask a question related to that?
Okay.
Mr. Serrano, so
Yes, sir.
talk more about that. I mean, I think what I'm hearing you say is we just don't want to demo the existing asphalt because we can use it for parking. And by not demoing, if we don't demo the asphalt, well, then we can't create pervious parking spaces. And so why go to the effort? I mean, that's kind of what I'm hearing. I mean, how many parking spaces do you have approximately on the property?
Spaces we have total? Over 200.
200 for fun, and that would mean 60 of your parking spaces would need to be impervious, right? 30%. You know, I mean, these perimeter parking spaces you have that are not central to the buildings, I mean, if you make those impervious, then you've met it. I mean, it's, you know,
Well,
it's,
I think that the spirit of the overlay district ordinance is when you're developing a piece of property that is undeveloped with trees, when you clear it and put pavement down, yeah, we can certainly put pervious pavement. What we're saying here is, let's not remove the existing pavement that's there, that are not pervious, they're impervious. But you know, as pavement gets older, they're actually old pavement, and water is infiltrating because if you look at the pavement, they're cracked and they're not new. The newer pavement will certainly create more runoff. But that's all we're saying here. It's is get an exemption from the overlay district ordinance of 30% impervious, because that's not usually in a standard conventional ordinance.
You know, if we look at sheet L1-01.1, maybe go up one, Jenny. It's working. Sorry. Yeah, all those spaces to plan left. There's 50 or 60 spaces right there. Boom, you're done. You got it. Simple, right?
Okay.
I mean, yeah, you have to remove asphalt. I get it, but
Yeah.
it meets the spirit of the code, and so anyway, I was wondering if you had a functional reason, but it's really just more about cost. It sounds like.
Yes.
Yeah. Okay. Thanks. All right. Keep going.
So the next one is 742, which is omit or to reduce the required 8-foot perimeter landscape buffer, tree islands, and land use buffers for the commercial flex space use. I think this is better looked at also on the landscaping plan. We can go there. To the north, there's an existing residence, single-family residence there on an AGR zoning. We are going to provide landscaping, an 8-foot landscape strip along what's an existing driveway. That driveway need to remain to allow for a fire truck to go through it. And we have also accommodating a request from staff to provide fencing on the structure, on the existing structure, to beautify the proposed project from the view of the resident on that existing site. So that's what that 8-foot perimeter landscape buffer is. The tree islands that I mentioned earlier, we will put those conventional trees and inverted islands closer to the building, but on the further away on the building, we will stripe the island so that that can allow the fire trucks to go through it more efficiently than if there are trees on those islands. And if we can go to the second exhibit that has the other one, the one before, yes. There is an AGR zoning adjacent to that property line to the west, and because of the width of that property, they can't really put any the existing structure on that property is closer to Main Street, which is further down to the south. So there's really no existing house or development in there. It'll just remain wooded like it is now. So we wanted to put those parking spaces along, there's an existing ditch that runs along that property line. And we will keep that. The county stormwater department had just asked for us to put vegetated filter strips along the pavement, which we will do, and that will act as a water quality function for our site. So that's the extent of the variance request for 742.
43?
743 is reduction of the open space. The ordinance says 10% open space, and unfortunately, we don't have 10%. We have 4% currently without, and that's removing, demoing that existing pavement and putting that 75-foot buffer along Main Street and a 50-foot buffer on Belvedere. And we will be happy to get that variance. We'll meet 4%, but not 10%. And then the overlay district is also asking for foundation plantings on the front of the building. We are willing to put maybe plants on planters as opposed to digging the existing pavement that is closer to the structure to avoid any unsafe condition with impacting the existing foundation of the building. Again, the intent of the developer is to use as much of the building as we can and the pavement structures around the building as we can.
Okay. Thank you so very much. I know that was a mouthful, so thank
sir.
you for being very clear about that. So let me see if we have some questions. We do have one to start off on that side, and then we'll come to my left. Yes, sir.
Thank you. Thank you, Mr. Serrano, for your explanation. I was wondering about, there's a property, I think it's to the south, that fronts Main Road, and you talked about you were closing the entrance on Main Road, and you were going to open up the entrance on Belvedere Road.
Yes, sir.
There seems to be a structure on that property that adjoins the property on the south side. There's a
This
building
property?
there. I don't know what it is. What is that?
Just south of us is Buck Construction. There's
Okay.
a 10,000 foot building.
Okay,
That's
the,
a multi-tenanted building
Right.
owned by the Buck family.
R.M. Buck Builders, okay.
Yes. The builders.
And there's no plans to have a buffer between that building and
No, sir, it's the
this?
same, it's the same use as ours.
Okay.
If you look at the overlay district
Right.
map.
Okay, thank you.
Any more questions to my right? Yes, sir.
Mr. Chairman,
Need some more time? I can come back to you. Yes, sir.
no,
Oh.
Mr. Serrano, when you're talking about 00742 and 00743, use language like, we're willing to do this and we're willing to do that, or we're going to do this and we're going to do that. And I'm just trying to figure out, where's the hardship? Like, we have paving, so therefore, we're not going to
I'm
make...
sorry, wait a minute. He's at the podium at this time, so you relinquish your right to speak at this time, so let him finish, and then I can come back to you if you like, please, sir, Mr. Greenspan. Thank you.
Thank you, Mr. Chairman. I mean, it sounds like you're doing 4% of the open space when we need 10. But there's plenty of places to put open space. You just don't want to demo the asphalt. And I'm looking for hardships here because we have criteria about which to judge, and because it costs too much or because we don't want to is not something we can support. So help us understand the hardship or the, and don't get me wrong, I get the use. I love this idea. Like, we have this great old building. We can subdivide it and use it for people that are working all over the island. Like, I want this to work. I like the philosophy of this thing. But we can't just do it because we like it. So help us out.
Yeah.
What are you saying? And then throw away. Get it for tonight.
So, remind me again the question.
On the cases that the one that ends in 4-2, which has to do with perimeter landscape area
Buffer.
tree island buffer, and then the case that ends in 4-3, which is about open space. Your comments were, and I'll use open space as the example. We're required to do 10, but we're going to do 4, and we're doing 4 by creating this buffer on Main Road and Belvedere, and that's all we can do. And so it's like, all right, well then, why are you requesting a variance? You know, where's the hardship?
The hardship that we came about, we are proposing to use on all those buildings. There are 3 buildings, approximately totaling 180,000 square feet. To make that work, we need parking spaces, which amounted to over 200 parking spaces. Right. And they are, we provided them scattered throughout the entire development. Now, we put the islands where we can, and we also put buffers on the front, and those vegetated strips that the county asked for, we provided them, and those count for the total of the open space. Now, if we use that extra 6%, we are going to maybe losing some of the parking spaces that we have. They're not. We don't have that luxury on the entire site if we are going to develop the buildings full.
But just in looking at the layout of the buildings and how the parking is juxtaposed around the buildings, there's some very gracious space between some of the buildings and parking spaces, like 40, 50 feet, where really you need 20, right? And so some of this is, and I don't blame you here. I'm not trying to like blame you, but some of this is it seems is that you have concrete and asphalt, and so we'll stripe it and we'll park it and we're good. Whereas if you had to get creative, you could probably tear out quite a bit of asphalt around the perimeter of the site and maybe achieve that 10% open space. And so again, the hardship seems to be like that it's difficult or costly to do, so therefore we're not going to do it. Not that I have to get a fire truck or I have to have a turnaround radius or there's a functional reason. Like that's the kind of stuff I'm looking for, and you can't use that because you hadn't used it yet. So
no. I wanted to mention in the back there are loading docks in the back.
Right.
And on the west side of Building A, and if you see, if we tear those parking lots and put those parking areas closer to the building, we can't have trucks backing up into it.
You have to show that. You have to help communicate to us how that works and the hardship. We can't just take your word for it. I mean, it doesn't work that way. And so where I'm going with this is show the ingress, egress of the truck, show how the turnaround radius, show how they back into the loading docks, show where the loading docks are, so we can understand, oh yeah, you need a vast amount of asphalt here and the parking. That's the kind of stuff that, as a board, we have to have evidence to support a variance. And right now we don't have any evidence. That's what I'm trying to help get. That's what I need from you. If it means getting more information, then let's get some more information. But I'm struggling with it because it sounds like the answer is because we just don't want to do it. That's what it sounds like.
No, no. If you would go in on the layout and paving plan C103.1. There. The hashed area doesn't show up very well on the drawing, but I can. Can I show this to you? Sure.
Or use the laser pointer maybe if that helps, but
I would suggest you use the laser. Ms. Working?
Is there a
or
laser?
Yes.
I'm not seeing
It's hard to see it.
How about come a little closer if you can, and see if you can use the laser. Maybe it's getting a little weak. The battery's getting a little weaker. That should be close enough right there.
well,
See
and if you go to, if I can help with this, maybe if you go to C1
Not working.
03.2, which is the one just before that. I'll try to use this exhibit to help make my point.
Well, you got a mic right there. You can talk and present from that mic if that helps. Maybe it's closer.
There's a line and it shows concrete on that line.
Can you see that?
We kept this open so we can back up trucks to those loading docks.
Okay. So what about everything to the south of that?
On the south of that?
No, like if I may.
Sure.
All of that. I mean, you've got 40 feet right there. It's unbelievable. All this stuff right here. I understand getting here.
Yeah.
It's all of this. You know, it's if you go back one slide, it's all of it. No, go forward one, sorry. Yeah. It's all of that asphalt right there. What's that for? All of that asphalt. And that's a ton of asphalt. And so that's the opportunity. I mean, you could park probably 20 more cars there and then get rid of the parking on the backside, or that could be this, you know, and this could be pretty open, right? That could be planted because you've got a drive aisle here. I mean, that's all I'm getting at is like it's hard to imagine a hardship for open space when there's a lot of open space. It just happens to be paved. If that makes sense.
Oh, okay, hold on one second. Good point. Mr.
I mean,
no, it's a very obvious point.
I can't support a criteria if I don't have evidence. That's all I'm saying.
Let me get to Mr. Jordan one quick moment, okay?
Okay.
Thank you.
Ask the staff this, or whoever else. I happen to know a lot about this subject because my dad was in the trucking business. If that building was built in the 1960s, trailers were 35, 38, and 40 foot long. They're 53 foot long now. So you might make an argument you do need that asphalt space for future truck usage. So I would say that I don't know if you thought about that or intend to use it. Maybe I shouldn't volunteer it. But if you think about that with a little common sense, they do need that space.
Okay, thank you. Mr. Williams.
Mr. Chairman, I, if I could rebut, I don't disagree with that in theory, but you got to show me. And the loading docks aren't all around every building, and so there's
The truck's got to get around the whole thing.
a fire truck does, but not every truck. And, I mean, we do these things in my business every day, so I know how this works.
Mr. Williams?
That's why I worded the way I did.
I guess my question is for the engineer here. And just to add on to the question by Mr. Marshall, I'm looking back at case 00741. You're asking for a variance request to reduce the required minimum 30% of parking, just like we're talking about, for commercial flex space use. But we don't know what use you're seeking. We don't have much information. So, and then going back to the criterias 1 through 7, we have to approve all 7 criteria. So, criteria number 6 has to not be the applicant's own actions. So I'm just having a hard time, if you could answer that question, how it's not the applicant's own actions in this case.
Well,
Why you need the variance?
the applicant action that I'm talking about is, this is an existing site, and we didn't put the pavement there. There are uses that they wanted to do for the building, and it's speculative at this time because we haven't identified the market. But one of those,
I'm sorry, you don't have the authority to speak at this time. I got one person that's at that mic. I'm sorry, Mr. Greenspan, but go ahead.
yeah, but one of the things that we have considered also at the beginning of this exercise is storage, site storage for the property. Now, again, it's already an existing pavement. It's been put down for some time and it's old. We just didn't want to tear it up at this time because it could be used for, for truck traffic. And that's one of the uses that is likely to be used on the property.
And then my other issue I'm having is why not put the land use buffers on this property, because that's part of the ordinances.
Yeah, we are putting the 8-foot buffer to the north, which is adjacent to an existing AGR use with a single-family home. But on the west, that there is no chance of that property getting developed in the future. It's that sliver of existing wooded site, and the owner can't develop that site.
So again, I'm having a problem with criteria number 6 because, I can't just approve something based on speculation. I'm speaking for myself. Thank you.
Now, there's also an existing ditch that runs along that property, that if we put a buffer, that would impact that ditch. It's right along the property line. The stormwater department that we consulted with suggested that we put vegetative buffer along that ditch so we could improve water quality. Now, if we put landscaping there, that would certainly nullify that plan.
Thank you.
Mr. Jordan, do you have a comment or question?
I have a comment, but this may not be the right time, so feel free to stop me. You won't hear my feelings. Could this be one of these situations like we have done before?
Yes.
Where there seems to be a willingness, as my colleague mentioned, to work with you, and I'm assuming that you want to work with us as much, or the staff as much as you can. Could this be one of those situations where they take some time to go back to staff and come up with something more substantive that y'all can agree to?
Okay, Mr. Jordan, I'm going to hold that, and I'm going to come across the board, okay? I'm going to get to you. Mr. Nelson, do you have any questions?
Not at this time.
Mr. Sedell, I hadn't forgotten about your question.
No, I think what would be helpful is that the variance being requested, that would take away from some of the pavement area. And what's not on here, you have big trucks and maybe even bigger trucks than were used when this facility was actually in operations as a tomato shed. You know, we could, if that was on the drawing, to show how the trucks would come in, where they had to turn around or whatever, and then justify the concrete. But I think the question is, there seems to be a lot of concrete that doesn't serve a need. Just looking at the drawings, and perhaps we don't have enough information to understand, you know, how that is required for the business as you envision it. And I understand that you don't know exactly what the businesses will be, but there will be tractor trailer unloading going on for sure. And that is known, and we could see how the space requirements for that and why it requires so much of the pavement to remain would be very helpful.
Mr. Truslow?
I just had a comment and a question. I think it'll be for you to decide. And I'm only speaking for myself, but I'd like to give you every opportunity to be able to succeed with an exciting project in compliance with the law. Are you asking us, or I'm not clear at this point, are you asking us to defer, to give you a chance to regroup, and no pun intended, but give us a little bit more concrete proposal on what you'd like to do, or do you want us to decide today?
Yes, sir. We ask it to be tabled today, and we'll come back next month.
He shot before I could pull the trigger, but you had it in the gun. I was trying to wait to take the shot. So I want to make sure that you understand this clearly. You have 4 applications before us tonight. You need a moment?
Yeah. Yes.
You're right, I could. Mr. Greenspan.
Yes, sir.
I feel, and it's been brought to my attention, that Mr. Greenspan may want to say something, because what we're looking at this time may be a deferral. Just as a barometer, it doesn't look pleasing for you tonight.
Yeah.
Do you want a minute to speak? Or would you like, Mr. Greenspan, would you like to say something?
If the board wants a deferral, we'll accept a deferral. We'll provide more information. We don't mind. There's a couple pieces of information that I think is important that we get across to you. Without site plan approval, without any permits, it's difficult, if not impossible, for us to come in front of you with a specific user and/or tenant, because we don't know what we're marketing. So I believe Mr. Nelson or one of the board members made the comment of we're making a proposal without knowing the uses. And I think it's important, we're making a proposal with uses that are very much planned or within the overlay. And we do know the uses. We haven't marketed the property, so we don't know the specific tenants. So that would be point number 1. Point number 2, as far as it relates to the parking and the vast amount of pavement, because I'm a business person and I too thought that there was a lot of pavement there and this would be terrific and we could do a new development. When in fact what we're trying to do is rehabilitate and respect what's there. It's not a new development. There is no room for more buildings. And we were hard pressed to lay out with the maneuverability, the existing parking spaces to keep it within compliance of what the code allows. So while it looks like there's a lot of pavement there, the reality is for the parking and the uses, there is not surplus pavement. Point number 3, and again, in terms of a deferral, we can have engineers and people lay that out and show you the truck traffic and the number of parking spaces relating to the code. Point number 3 is 98% of this site is currently paved. When we're done bringing this up into compliance, we're adding buffers, we're adding trees. And I hear the bias of the board, and I just find it somewhat ironic as a Johns Island resident. I read the newspapers, everybody's spending all their time protecting trees and not wanting people to cut them down. And here I have existing pavement, and I hear people saying, rip it up and plant more trees. So again, our objective here is to bring the property into compliance. If the board would like us to defer the application in order to provide more information, we will do that. But like I said, we are doing everything we can. The variances that we are putting forth are as a result of us being unable to rehabilitate the existing buildings without these variances.
Thank you, Mr. Greenspan. I would, it is your choice. You have several members in which to impress and to impose your will. We could do either. We can vote on what we have and what has been presented, or we can give you a deferral. Now, it's not our determination to make, it's your decision to make, sir.
So, like I said, we'll accept a deferral. I'd like to increase our chances of success. In order to increase our likelihood and chances of success,
okay.
Are you able to articulate what it is that you need us to provide specifically for you for the next meeting?
So,
because
that's a good question. So generally speaking,
because I'd like to provide it,
and we want you to be legally binding, I will allow staff to do that. You should have no need to come to this body if you were to work within the ordinance.
Could you say that again? I didn't really
I
hear
said
what
you
said.
would not need to come to this board if you were to work within the ordinance and the guidelines that are presented in Zeldar.
Understood.
You're asking for a relief because you have some hardship. We have not, I'm only speaking for maybe myself and what I've heard. You may not have presented enough hardship. So you may need to go back to the drawing board and figure out how you can eliminate some of these issues that have been presented tonight or not been presented. So you're asking, if I can clearly state, you'd like to have 40, 41, 42, and 43, you'd like to have a deferral for that?
Yes.
Okay. Ms. Okay, so we had to place it on the docket. It'll be up to 90 days, I would think. And you would have to work with staff to try to figure out what month. And please try to work with staff to try to figure out how you could best work your layout and engineering plans to fit within the guideline where you may have a hardship, because that's what we're looking for, is hardship.
Mr. Chair, point of order, the board has to vote to accept the deferral or not.
Yes, yes.
One other point of order, I believe we don't have to request deferral of the applicant. I believe we can make a motion for deferral anytime we want based on lack of evidence. So,
Of course.
I mean,
I'm just
for the
giving him that
record.
opportunity.
Right, but we don't have to, is my point.
Very correct.
So anyway, but I'll move for a deferral.
Okay. So we, Would you say for all four, please?
And in case, BZA case 12-23-00741 and 12-23-00742 and 12-23-00743, and I missed 40, and -12-23-00740, I move for deferral.
Okay. Okay, we have a second. Question, discussion. All those in favor, please indicate.
I just want to say it. I'm in favor of deferral, and I think that would be a wise decision under the circumstances, but I wouldn't, I would defer to, if you're using that word, defer to the applicant to make that decision.
Well, he did. They did.
He's
He's made that.
All right.
I don't disagree, but I just think under the procedural right, we can also do the same. But I agree with you. I agree.
All those in favor? Please indicate by saying aye. Aye. It is unanimous. So please work with staff to get the next available date.
Yes, sir.
Okay.
Understood. Thank you.
All right. So that's going to take care of all the cases for tonight. Ms. Working. We have some.
Yeah.
Just hold on one moment, board members, please.
Yeah, March is our annual meeting. It is full. We are full of cases. And will be every month, basically. So we'll meet at 3 in the committee room for the annual meeting and then come back over here at 5.
What time's the annual meeting?
3.
3. And that will include training, so.
And we're going to have a really good lunch.
Okay, is that right? Is that right?
All right.
I'm hearing ribeye steaks.
Keep wishing. Anything else, Ms. Working? At this time, the meeting's adjourned. Thank you.